All right. Good evening, ladies and gentlemen. I'm only saying gentlemen because it sounds like there are some gentlemen with us in the attendees, but the only folks I can see in video are ladies. So good evening, ladies. I presume all four of you are my advocates. Thank you very much for being here, and thank you for bearing with us as we figured out the conflict issue earlier with one of our jurors. We now have two scoring jurors with me in the room, Ms. Santos and Ms. Farut. My name is Deanna Sada. I will be your ruling judge. We can do brief introductions about us a little later, but I think it's better to jump right into the trial. And so without further ado, if I can have all of you guys introduce yourselves, and then once you do, I'll swear you in and get going. We'll start with plaintiff's side. Entries of appearances, please.
Good evening, Your Honor. My name is Erica DeMeglio, and together with my co-counsel, Sarah Morris, we represent the plaintiff, Cam Donaldson.
Good evening to you both and welcome, and thank you for rolling with the punches in 2020 and doing a trial tournament via Zoom. I don't know how you guys are doing it. I don't know if I could have, but kudos to both of you, and I'm sure to your opposing counsel as well. Kudos to all four of you is what I meant to say. Let's get defense's entry of appearances, please.
Good evening, Your Honor. My name is Shannon Reed, last name spelled R-E-I-D, on behalf of the defendant, Karen Baja, who is also on call with us this evening.
Great. Okay. Good evening.
Good evening, Your Honor. Tanaz Nur Mohammadi, last name spelled Noormohammadi, representing the defendant, Karen Baja. And today, the defense has two motions in limine and 4 housekeeping matters to address.
Thank you to you both and welcome. Again, same message to you guys. Thank you for rolling with the punches and doing this via Zoom. And thank you for letting me know about the outline of the motions and housekeeping matters that you have. I do appreciate that. I think we'll get to yours after we hear plaintiff's sides, at least housekeeping matters. What I like to do is get all housekeeping matters attended to first. So I'll do plaintiff defense, and then we'll do motions in limine from plaintiff and then motions in limine from defense. I hope that's okay with everyone. That is the procedure that I think is best. Before we do that, let's everyone raise your right hand and please indicate by saying I do if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do. I do.
Excellent. Great. And so what we'll do, if it's okay with defense, I know you gave me the outline of your motions and housekeeping, and I do appreciate that. Let's go ahead and start with plaintiff, however. So plaintiff side, are there any preliminary matters aside from substantive motions in limine that we should attend to before we get started?
Yes, Your Honor, we do have a few housekeeping matters. First, due to the virtual nature of this trial, may we assume that opposing counsel has already seen all exhibits before we offer them to each witness?
I think that's a fair assumption. Does defense agree with that?
Yes, Your Honor.
Great. Okay, let's go ahead and make that assumption then.
May we also remain seated during objections so that we remain within view of our cameras?
I honestly wouldn't know any better, so I think that's a great idea. You could have shorts on. I would have zero clue. So this is the nice thing about 2020, I guess. Assuming defense doesn't have any objection to the procedure, I'm fine with that as well. Go ahead. What else?
We'd also like to invoke Rule 615, the constructive sequestration of all witnesses, with the exception of party representatives. The plaintiff's party representative is Cam Donaldson.
Okay, and so Ms. DeMeglio, I don't know as much about this case as I would like, but my understanding, however, is that all of your experts are either advisory witnesses such as experts, or all of your witnesses are advisory witnesses such as experts or party representatives. And so are you seeking to sequester experts as well?
Yes, Your Honor, the experts are the only witnesses we're seeking to sequester today.
Okay. Well, what is defense's position on that?
Your Honor, defense's position is that we request the experts remain in the court to be able to hear everyone's testimony.
I do tend to agree. I think that experts have, especially if they are testimony experts and they are going to testify in the trial, They can be your advisory experts, and they can remain and they can opine on the testimony that they're hearing. And am I right in assuming that the only other witnesses aside from experts are party representatives for defense as well?
Yes, Your Honor.
Okay, and so I will allow defense to have their expert sit in on the trial. I will give plaintiff a choice, since you are asking to invoke 615, whether you want your expert to be sequestered or not. What I will tell you is I will not make your expert be sequestered, and your expert can be in the courtroom or constructively in the courtroom if that's what you want as well. So what would you like to do, Ms. DiMiglio?
Because the defense's expert will remain in the courtroom, we'll have our expert remain in the courtroom as well.
Excellent. Well, then, assuming that no other witnesses will be called aside from the 2 experts and 2 party representatives, there will be no sequestration order. Please alert me if there is a surprise witness that I don't know about who shows up, and then I will enter a sequestration order, at least for that witness. I'm assuming, actually, let me enter a sequestration order for any surprise witness now. Any other housekeeping matters, Ms. DiMiglio?
Yes, Your Honor. May we assume that each witness already has all potential exhibits in front of them?
I think that's a good assumption. In fact, you do not have to ask me to allow the witness to pull the exhibits for authentication purposes. You can simply say, Ms. So-and-so, please pull exhibit 13. Is this a fair and accurate representation? All that good stuff. Because the last trial I ran took at least 20 minutes longer because of that. So let's skip the formalities that do not need to happen so that we can make this less than 5 hours long.
Yes, Your Honor. And finally, may we assume that all witnesses are constructively sworn?
I was going to say that to each witness as they came in, but since all witnesses seem to be here, please assume that you are constructively pre-sworn. And once you get in, we'll just dive right into the first question. So that is a good idea. Thank you for bringing that up.
Your Honor, the plaintiff has no further housekeeping matters.
Thank you. And what about defense? Any preliminary non-substantive matters to attend to?
Yes, Your Honor. The plaintiff took care of one of our housekeeping matters, so we only have 3 now.
Great.
Your Honor, may we be permitted to stand for opening and closing arguments, but remain seated for direct and cross-examinations?
You can do whatever you'd like since you're doing the whole Zoom fiasco.
Does Your Honor prefer that we tender our experts?
I'm not going to assume that any expert is pre-qualified. I do think you have to tender him, and I am going to give each side the opportunity to voir dire the expert to narrow the scope of their tender if they so wish to do that. So you absolutely do have to qualify your experts, ask to tender. I will then look at the other side, either ask for an objection or voir dire. Having said that, if you guys have spoken and have agreed that both of your experts are qualified, tell me that now, and then we can save that time as well if you'd like.
And our last housekeeping matter is, throughout the course of the trial, counsel may request for a sidebar. We request that this be done constructively and on video conference so that our evaluators can hear our arguments.
Absolutely. All sidebars, all limiting instructions, all things that would normally be done outside of the presence of the jury should be assumed to have been done outside of the presence of the jury, but we will still do them in this forum so that everybody can see everything. Yes.
And that concludes defense's housekeeping matters.
Great. I have a couple of my own. I think that for opening and closing arguments, it sounds like the rules have changed slightly in the Summit Cup in that they want all of us to turn our videos off with the exception of the advocate. So I think the advocate is just going to be looking at yourself while you're doing an opening, which is probably the best thing because all of my openings, the best versions of them have been in the mirror in the bathroom before trial anyway. And so maybe it is better that you just look at the screen with you in it while you do your openings and closings. I think it might be because of connectivity issues. And so what I will ask for all advocates respectfully is if you can please all turn your videos off, because I have enabled the feature on Zoom that hides all participants whose video is not on. And so the only participants that will show up in the gallery view are those whose video is on. And so once we start plaintiff's opening, if everyone can please turn your video off and obviously mute yourselves, this way we'll only have either Ms. DiMiglio or Ms. Morris, whoever's doing opening, appear. Same thing for defense, and then same thing for closings. Our scoring jurors, please keep your video off at all times. Our witnesses do the same thing. But during examinations, the attorney examining the witness and the attorney crossing the witness should all be on, as well as myself. So there should be 4 people on at all times during examinations. Does that make sense for everyone? And does everyone agree with that procedure?
Yes, Your Honor.
Excellent.
Yes, Your Honor.
Okay, so it sounds like we've got some motions in limine. Plaintiff, any motions in limine on your part?
Yes, Your Honor. Our first motion in limine is that the plaintiff would like to request that the court take judicial notice and admit as an exhibit Lou Donaldson's request for a temporary restraining order. This document can be found on page 55 of the case packet and is labeled with base number ending in 0016. The court can admit this document and take judicial notice of it under Federal Rule of Evidence 201.
Okay, what is the defense's position on that?
Your Honor, may I have a moment to confer with my Federal Rules of Evidence book?
Sure.
Your Honor, we object on the grounds of inadmissible hearsay, improper character evidence, and that its prejudicial impact substantially outweighs any probative value.
Okay, I normally will have, I think any judge normally will get some sort of heartburn by admitting a temporary restraining order in a civil case or a criminal case for that matter. Traditionally speaking, restraining orders are admitted in criminal cases where the allegation is a violation of protection order or something to that effect. But normally speaking, protection orders do not come in for propensity purposes. I do understand the judicial notice request, and I appreciate that. That's a very clever argument. Having said that, I'm not sure if it is within my jurisdiction. I am not sure, based on, because I haven't seen the document, I'm not sure if it is something that I can take judicial notice of within my jurisdiction. But even if I could, it still needs to go through the other rules of evidence. And while hearsay is not particularly my biggest concern for the TRO, the propensity rule is. Having said that, Ms. DiMiglio, I will tell you, I am not denying your motion in that I am not denying the admissibility of the TRO, but I do need to hear a purpose aside from the propensity purpose for which you want to admit this. And if I hear that, I will probably admit this if it is tied to this trial in some way. I'm not going to be able to ascertain that in a motion in limine. I think I can only see that once the evidence comes in. So I'm going to reserve ruling on that. But what I will tell you is it's not going to be judicially noticed. I think it might be admissible evidence. It's just not going to be admissible evidence now. You're going to have to articulate to me how it's not propensity evidence, and then it will come in. Does that make sense?
Yes, Your Honor.
Excellent. What is your next motion in limine?
Your Honor, the plaintiff seeks to admit the vehicle maintenance form from the Pioneer Sheriff's Office. It's been previously marked with Bates number 0017. It's located on page 56 of the trial packet.
All right, well, what is your ground for admitting that?
Your Honor, we seek to admit this pursuant to Rule 8038. It is a public record that will serve to provide inconsistencies with the testimony that the plaintiff will offer from Officer Bannister and as to the legitimacy of that testimony.
All right, what is the defense's side?
Your Honor, we object on lack of foundation. To expound, and if I may provide an offer of proof.
Please.
So there is an unavailable witness, Carl Bannister, who reported his transponder as malfunctioning, and as a result, reported that, and a maintenance technician fixed the malfunctioning transponder. However, Carl Bannister never saw this this maintenance report form. He can only admit that he reported it, not that he saw this actual maintenance report form. Therefore, it's a lack of foundation.
So if what defense is saying is true in how little foundation plaintiff is going to be able to provide, I will tell you right now that I'm leaning towards leaving it out. I can't imagine this coming into evidence without much more foundation. I don't know if what defense is saying is true. I don't have a reason to distrust you, but of course, trials are trials. And so, Ms. Morris, if you want to introduce this and you feel like there's foundation above and beyond what defense just said, then please try to do so. And defense, you should object if you still feel like it lacks foundation. What I'm telling you right now is, based on what I've heard, I'm leaning towards not letting this in, subject to further foundation that I haven't heard about being laid. Any other motions?
No, Your Honor, the plaintiff has no further motions in limine.
Excellent. What about defense?
Your Honor, before I turn it to my co-counsel to give her motions in limine, may I request that no mention of the request for a temporary restraining order be mentioned in any opening statements?
Well, let me ask plaintiff first. Plaintiff, do you intend to reference the temporary restraining order in your opening statement, or was that your intent in the beginning?
It was, Your Honor, yes.
And how would you reference it?
If I may proffer, we will reference it while describing the state of affairs between the defendant and Lou Donaldson prior to his disappearance. We can certainly lay foundation during trial, but the temporary restraining order is certainly relevant in establishing what their relationship was like in the immediate months prior to his disappearance, especially the contents of the temporary restraining order. So it's relevant to Lou Donaldson's disappearance and ultimate death.
Well, one thing I can tell you, Ms. Morris, is I don't question its relevance. I think a temporary restraining order between two people is relevant in any trial involving those two people. I think where my biggest issue is the propensity rule. Having said that, I am somewhat familiar with this case, not very much, somewhat. And what I can tell you is with sufficient articulation of exceptions to the rule, I am leaning towards admitting the temporary restraining order. Having said that, if you believe that in this trial, you have a good faith basis that this TRO is going to come in, I will let you talk about it in your opening statement. But you, as an attorney who has taken the oath, who must believe you have a good faith basis to introduce evidence before you talk about it in opening. If you believe that that is the case, then that is your prerogative. And if you talk about a TRO and you end up not successfully admitting it into the trial, I suspect that defense counsel will be all over that in closing argument by accusing you of making stuff up, which they should. So I am going to leave this up to you, whether you talk about it in opening, but that means you have to have a good faith belief it's going to come into the trial.
Certainly, Your Honor. May I ask a quick clarifying question?
Sure.
The TRO, there are multiple issues that I'm sure defense is prepared to raise, but there's the existence of the TRO and then there's the contents of it. Would the court permit or recognize that distinction and the admission of the TRO as it exists versus the contents of the TRO with purposes for the opening statement and the rest of the trial.
Yes, I think that there is a distinction between those two things, and I think this is probably one of the heftier pieces of evidence that there should be some good evidentiary arguments about. I hope to see some good evidentiary arguments about this from both sides. I do recognize that there's a difference between the existence and the content, and I've seen the 3 paragraphs in the content of the TRO. I will tell you that the onus is on you, Ms. Morris, by wanting to bring this in to articulate purposes that overcome 404, that overcome 403 even, especially since the content is not particularly peachy, to be able to bring this in. And so if you as plaintiff's counsel have a good faith belief that this is going to come in this trial, I'm not going to mess with your opening, especially for the purposes of this forum. I think if this was happening in some district court, they probably will limit your opening. I want you to do your opening, and I want to see your advocacy based on how you've prepped your opening. But I also think that there's a good possibility it might come in. And so I'm going to leave it up to you on both fronts, substance and existence. But you have to believe that it's going to come in order to do that.
Excellent. Thank you, Your Honor.
Any other motions eliminate from defense?
Yes, Your Honor. The defense has 2 motions in limine. Your Honor, today Karen Baja is being wrongfully accused of having caused the death of her husband, Lou Donaldson, simply because she inherited his estate and received his life insurance policy payout. Our first motion is to exclude evidence of Ms. Baja's prior juvenile conviction. One of the witnesses in this case claims to have knowledge of a prior juvenile conviction that Ms. Baja received when she was 17. We move to exclude this evidence as inadmissible under Federal Rule of Evidence 609B and D, as it is over 10 years old and further inadmissible in a civil trial.
What is the conviction for?
As an offer of proof, Your Honor, the conviction is for misdemeanor assault.
On her husband?
No, Your Honor, this was prior. This was when she was 17 years old.
Got it. Okay. What is the plaintiff's position on that?
Plaintiff has no objections to the exclusion of Ms. Baja's juvenile conviction.
Okay, well then that sounds like a stipulated motion. Thank you very much for working together on that. Ms. Reed, any other motions eliminate?
Yes, Your Honor. Our second and final motion is to exclude evidence of Ms. Baja's refusal to submit to a polygraph examination as lacking in foundation and also unduly prejudicial under Federal Rule of Evidence 403.
Plaintiff's position?
Plaintiff has no opposition.
All right, well that's just great. Do you guys want to settle the case and just call it a night? No? Okay, I thought I'd try. Any other motions, Ms. Reed?
No further motions, Your Honor. The defense is ready for trial.
Excellent. Well, why don't we just take about 30 seconds. Everybody please turn your video off with the exception of either Ms. Morris or Ms. DiMiglio, whoever is doing the opening statement. I'll turn mine off as well. And you can start whenever you're ready. Actually, before you start, this is one thing I was confused about in the last trial. Who's keeping our time?
Your Honor, the witnesses, the woodshed witnesses for each side are timekeeping and control.
Excellent. All right. Thank you. Thank you very much for that clarification. Do you mind maybe giving me a time check after the plaintiff has rested its case in chief? This way, both sides kind of know where they stand. And then maybe again before closing arguments, because I know at the last trial, the witnesses kind of dropped out before closing arguments and we just didn't know the time anymore. And so please give us that time check before you leave, if that's okay with you.
Certainly, Your Honor, we will do that.
Of course. And if Your Honor would like to enable the commenting on this, I don't know if that's something you're able to do. We can also put those in the chat as well.
Yeah, that's fine with me. I don't want to mess with any settings. See if you can send me a test chat while Ms. Morris gets ready and if that works.
Yeah, it looks like those are disabled, so we can just say it at halftime.
Okay, yeah, please. And I'll ask for that as well. Okay, well, I'm going to turn my video off and Ms. Morris, you have the floor. Please proceed with your opening whenever you are ready. Thank you.
When someone steals something, they must be held accountable. That is what this case is about, as you will hear today. We will prove to you that the defendant is responsible for stealing everything from our client, Cam Donaldson. You see, we are here for 3 reasons. Because of a murder for which the defendant had clear motive, and as a result, a son is in mourning. Ms. Baja has stolen everything from our client, Cam Donaldson, including his livelihood, his business, and most importantly, his father, Lou Donaldson. Murder, motive, mourning. Members of the jury, my name is Sarah Morris, and I, along with my co-counsel, Erica DeMeglio, will prove to you that Ms. Baja is responsible for the death of Lou Donaldson and the suffering it has caused his son. Allow me to take a few moments to share what you will learn today. Lou and Cam Donaldson were incredibly close, not just as father and son, but as business partners. Cam will share with you today how he and his father built Wild Wild Life, a big cat sanctuary from the ground up. Cam poured everything into this business, and he served as his father's assistant for 20 years. That Friday afternoon in 2012, when Cam said goodbye to his father after a long day of work, he had no idea it would be the last time he would do so. Which brings me to the first reason we are here today: murder. Lou Donaldson was married to the defendant, but as you will learn today, their relationship was severely troubled. Lou was a private man who functioned best when he could have some time to himself, and he was known to get away from time to time. This did not sit well with the defendant, and you will likely hear the defense share with you a story about a mistress that Lou Donaldson allegedly had, though there will be no evidence to support her existence beyond the sole word of the defendant herself. In the weeks and months leading up to Lou Donaldson's disappearance, things were getting increasingly worse. They got so bad that at one point, Lou Donaldson sought a restraining order against the defendant. A few weeks later, the pair fought again, and once more, Lou Donaldson had fear. In fact, he went as far to tell our client that if something were to happen to me, be sure to have the police look into Karen, because she will be responsible for my death. Lo and behold, 2 weeks later, Lou Donaldson vanished forever. Now, Lou Donaldson was never seen again after August 17th, 2012, but the defendant certainly was. You will hear how on August 18th, she left her home in the middle of the night at 3 a.m. to go buy formula for some tiger cubs at the grocery store. On the way home from this curious errand, the defendant's car broke down, and instead of calling her husband to pick her up on the side of the road, she called her brother, Officer Carl Bannister, a sheriff's deputy who was on nearby patrol that night. Officer Bannister says that he picked Karen up and dropped her off at her home a few miles away, but the evidence will show that the vehicle tracker on Officer Bannister's car showed no movement between 3:20 a.m. and 6:30 a.m. that night. Officer Bannister says he dropped the tracker off for maintenance the next morning, but you will learn that when he dropped that tracker off, it was fine. It was in working condition. Now, the next morning, August 19th, Cam Donaldson awoke to the sound of a distant buzzing alarm just as the sun was rising. It was the security system at Wild Wild Life. So Cam jumped in his car to go see what was wrong. When he arrived, it was clear that someone had broken in. The padlock on the front chain had been snapped and the back entrance to the office had been destroyed. And who does Cam see walking out of the Wild Wild Life office but Miss Baja and an unidentified partner, carrying with them lock cutters and a lockbox containing Lou Donaldson's last will and testament. Now, at this point, Cam had no idea that his father was missing, so this incident seemed strange, sure, but not immediately suspicious, sinister. But a week later, when Lou Donaldson's abandoned van and personal effects were discovered 40 miles away, Cam knew something was seriously wrong. Before he knew it, he'd been fired from his job, Ms. Baja had taken full control of Wild Wild Life, and Cam's father was nowhere to be seen. That lockbox that he saw Ms. Baja carrying out of the Wild Wild Life office, the one that contained Lou Donaldson's will, suddenly it all made sense. Which brings us to the second reason we are here today, and that is the motive that Ms. Baja had to murder Lou Donaldson. You see, in addition to the marital problems, there was a great deal of money at stake. Members of the jury, I ask that you pay especially close attention to the discussion of Lou Donaldson's will over the course of this trial. You will learn that Lou Donaldson had an original will kept in that lockbox that split his assets 4 ways, but that document has vanished. Instead, Ms. Baja has relied on a dramatically new document, one that leaves all of Lou Donaldson's assets to her. This new will is notable for 3 very important reasons. First, you will learn that this new will contains the term, "should I die or disappear." The term disappear is not only rare in a will, you will learn that it is nearly unprecedented. Second, the evidence will show that the signature at the bottom of this new will does not match known samples of Lou Donaldson's signature. And third, this new will that leaves all of Lou Donaldson's assets to Karen Baja was signed by Lou Donaldson just 2 days after he sought a restraining order against Karen Baja. Nevertheless, that very next Monday after Lou disappeared, Ms. Baja took over Wild Wild Life. She fired our client and she never looked back, leaving Cam without his livelihood, without his business, and without his father. Which brings me to the third reason we are here today, and that is because a son is in mourning. Cam will never see his father again. They will never share another Sunday dinner or another inside joke. Murder, motive, mourning. It will be up to you to decide whether it is more likely than not that the defendant is responsible for Lou Donaldson's death and the suffering it has caused our client. It is a tragic reality that an apology isn't enough to cure Cam's mourning. A sorry won't bring Lou Donaldson back. But today, at the end of this trial, my co-counsel, Erica DeMeglio, will stand in front of you and ask you to do the next best thing, which is to hold the defendant liable for the murder for which she had such clear motive. Because when someone steals something, they must be held accountable. Thank you.
Sorry, I forgot to unmute myself. Thank you, Ms. Morris. Ms. Reed, sounds like you're going to do opening for defense.
Yes, Your Honor. May I have a moment to adjust my camera?
Certainly, take your time. And while you do that, excuse the crazy people behind me. It's just a painting that my mother gifted me, which I love, but
Beautiful.
they do look pretty crazy on camera, so
May I proceed?
you may.
Members of the jury, no one here denies that Lou Donaldson's disappearance was devastating. On August 17th, 2012, Lou Donaldson made the decision to get on one of his planes, to fly with a suspended license and without a flight plan, and head to Costa Rica without saying a word to the people closest to him. That day wasn't the first time Lou Donaldson had left, but it was the first time he never came back. That day, plaintiff lost his father, and Karen Baja lost her husband. But instead of coming together to mourn their loss, Cam Donaldson has spent the last 5 years searching for someone to blame. And today, he's pointing the finger at his father's wife and heir, Karen Baja. But members of the jury, he can point the finger. He can't prove the case. But before we get into any of that, I'd like to introduce you to Lou Donaldson's wife. Ms. Baja, can you turn your camera on, please? Members of the jury, this is Karen Baja. Since her husband's decision to leave, she's been running the Wild Wildlife Sanctuary, and she continues to honor her husband's legacy by protecting and caring for the lions and tigers at the sanctuary. Thank you, Ms. Baja. You can turn your camera off. But today, the plaintiff is accusing Ms. Baja of the wrongful death of Lou Donaldson. As the judge will instruct you, the plaintiff can't just make accusations. He has to prove them. And today, the plaintiff will fail to prove their case because the evidence will show two things. First, that Lou Donaldson chose to leave his wife and son on August 17th, 2012. And second, that Lou Donaldson chose to leave his estate to Karen Baja. So let's start by taking a look at the first thing that the evidence will show, that Lou Donaldson chose to leave his wife and son on August 17th, 2012. Today, you're going to hear from Karen Baja herself. She'll tell you about the very first time she saw Lou Donaldson. It was love at first sight. He was her soulmate, and that it was their shared passion for big cats that brought them together. For 12 years, they worked side by side, dedicating their lives to protecting the big cats at Wild Wildlife. But we'll also learn that Lou Donaldson had another side, a secretive side. You'll learn about the planes that he would regularly fly to Central America, planes that were unregistered, that didn't have flight plans, and who were piloted by Lou Donaldson himself on a suspended pilot's license. Today, Ms. Baja will take us through those couple of months leading up to Lou Donaldson's decision to leave. She and her husband are in what she believes to be a loving and committed marriage. But then, all of a sudden, he says he's seeing someone else. She's in Costa Rica, and he wants to be with her. Not willing to give up on their connection, Ms. Baja tries to work with him to figure things out. But by August 2012, Lou Donaldson has made his decision. He's moving to Costa Rica, leaving his wife, his son, and his company behind. And now it's August 18th of 2012, and Ms. Baja has just finished a long evening caring for 2 newborn tiger cubs that were rejected by their mother. And suddenly she realizes that her husband is gone. He's gone and he isn't coming back. And it's up to her to keep their passion project going the way her husband wanted them to. Which brings me to the second thing that the evidence will show, that Lou Donaldson chose to leave his estate, including Wild Wildlife, to Ms. Baja. As we'll learn, it was Ms. Baja who shared Lou Donaldson's passion for big cats. It was Ms. Baja who cared for the cats. And it was Miss Baja who immediately turned her grief into action by continuing to run the Wild Wildlife Sanctuary and ensuring that all the lions and tigers were cared for in her husband's absence. Now, you're going to hear a lot about Lou Donaldson's last will and testament today, and that will left his estate and his company to Miss Baja. Now, Cam Donaldson understandably was upset by that. He'll tell you that he thinks the company should have gone to him. But the evidence will show that it was his father's wish that the estate and the company be left to Miss Baja. You're going to hear from Chris Reynard, a document examination expert who will come before you and explain how he utilized his decades of experience to determine that the will Miss Baja presented was Lou Donaldson's authentic last will and testament. Because you see, Lou Donaldson knew that by giving his estate, his company, his passion project to the woman with whom he worked side by side for 12 years to preserve big cats was the easiest way to ensure that everything would be taken care of. Members of the jury, throughout this trial, you're going to meet both Karen Baja and Cam Donaldson, and you'll see how they grieve the loss of Lou Donaldson. Miss Baja turned her grief into devotion for the sanctuary. But Cam Donaldson is still in denial. Denial that his father left and denial that the sanctuary was rightfully given to Miss Baja. But while he can point the finger, he can't prove the case. And that's why, at the end of this trial, my co-counsel, Tanaz Nur Mohammadi, will stand before you and ask you to return the only just verdict, the only right verdict, a verdict in favor of Karen Baja.
All right, thank you very much for that. Thank you both counsel. I think we will turn to plaintiff's case in chief now, and plaintiff, you may call your first witness.
Yes, Your Honor. Plaintiff calls Cam Donaldson.
All right. Mr. Donaldson, you've been previously sworn, and Mr. Miglio, your witness.
Good evening, Mr. Donaldson. Please introduce yourself to the members of the jury.
Yeah, my name is Cam Donaldson.
And how are you related to the defendant?
Karen is my stepmother.
Why are you here today?
After my dad disappeared in August of 2012, I started to believe that Karen might have murdered him and forged his will to leave her everything. She took my dad and she took the business I was hoping to take over. And I think she had a motive to take everything from me, and I want her held accountable.
Objection, Your Honor. Speculation, improper opinion, specifically in the statement, I believed that Karen Baja murdered my father.
I do see your point, but I think that, the witness is basically introducing his presence here. I think that I can provide a limiting instruction to the jury to take that statement for his opinion only. But I think he's said what he said. I'm going to overrule that objection for that purpose, but technically you are right. It is speculative. So
Yes.
We'll just proceed. Thank you.
Now, Mr. Donaldson, I'd like to unpack that a little bit. Specifically, why you think Karen Baja had a motive to kill your father and take your business. Do you have any specific reasons to believe that the defendant would want to do those things?
Yeah, every time I saw Karen, she was always playing with the tigers and hanging out in the sanctuary. She seemed downright obsessed with the cats, and she seemed like she loved wild wildlife.
To be clear, what's wild wildlife?
Wild wildlife was my dad's business. It's a sanctuary we keep for big cats. We have all kinds there, but we specialize in tigers.
Did you ever work there?
I did. I worked at Wild Wildlife for 20 years.
And what was your role at Wild Wildlife?
I mean, I was kind of responsible for running the place. I scheduled the meetings, I wrote checks for my dad, answered the phones, ordered any supplies he needed, anything like that was all on me.
Why were you the one that was responsible for running your father's business?
My dad was just a busy guy who went on a lot of business trips.
What mode of travel did your father usually take for those business trips?
He would fly usually. He flew so much that eventually it must have become just cheaper and easier for him to fly himself places, and that's what he would do a lot of the time.
Now, based on your observations, how did your father's busy schedule affect his relationship with the defendant?
So I'm not sure about all of the specifics about the relationship, but as time went on, I'd hear them argue a lot more. Their marriage started to seem to get pretty rocky. Eventually, my dad wanted to get a divorce.
How do you know your father wanted a divorce?
He'd be really open about it. I mean, he first brought up the idea to Karen in must have been June 2012, about 2 months before he was murdered.
Objection, Your Honor. Improper opinion. Move to strike the statement 2 months before he was murdered.
What's
Mayor
the, well, I just want to understand, Mr. Miglio, I'm sorry to interrupt, but I just want to understand the objection. So is this like a 702 objection type scenario, like an expert objection, like an improper lay opinion, or
Yes,
is
Your
this like a lack of personal knowledge type of objection?
Honor. It is an improper expert opinion, and if I may also add, lack of personal knowledge.
Okay. All right. So, so plaintiff, I'll let you go ahead and respond now to both of those objections.
Your Honor, the plaintiff isn't offering this as any type of expert opinion. This is simply the witness's opinion of what he felt happened to his father. This is the plaintiff in a wrongful death action, and so he's entitled to explain why he feels that his father was wrongfully killed by the defendant. Throughout the rest of this direct, the witness will be laying the facts and circumstances as to why he believes that.
Okay. So typically speaking, I mean, I do think that the first objection that popped into my head is a 602 objection, which is a need for personal knowledge. It's a lack of personal knowledge. How would he know this? Unless someone told him. And if someone told him, then it might be hearsay. And then I think we get into hearsay territory. So I do have a hard time going into specifics about what his father said that makes this witness think that his father wanted a divorce in a very specific incident. Having said that, I do think Mr. Donaldson, being the alleged victim's son, can easily testify that their relationship was rocky, that he thinks it was leading towards divorce from what he understood, from what he felt. But if he's going to reference specific statements or maybe the temporary protection order or whatever it may be, you're going to have to overcome some hearsay grounds. So the reason my ruling is a little long is because I don't know where he's getting that information from. If it's just his general perception of what's going on in the relationship, I'm going to let him talk about that. He's the son, he should know. But if it's my father told me 2 months before the whatever that, you know, I think he's going to get a divorce, I still think that comes in, but you are going to have to articulate a hearsay exception in order for it to do so. My apologies for the long ruling. I'm going to sustain that objection in the sense that it, the specificity of 2 months before being or referring to a particular statement by the father needs a little more foundation or hearsay exception. I'm going to give you a little leeway, Ms. DiMiglio. Why don't you proceed a little bit with your questioning, and we'll see where the witness is getting this information from. And Ms. Noor Mohammadi, please object again if he starts going into specific statements. So I'm going to give you a little leeway.
Sorry.
No, that's okay.
May I proceed?
Yeah, I'm gonna give you a little leeway, and why don't we see where this goes? And then I'm gonna give defense counsel an opportunity to object again if it goes a little too far.
Do you know whether your father actually did file for divorce?
He didn't. As soon as he brought up the idea of a divorce to Karen, she screamed, "I'll kill you." And my dad ended up filing for a restraining order instead.
Objection, Your Honor. Hearsay. Move to strike. He heard the same. He heard, "I'll kill you."
May I respond?
Yes.
The statement was by Karen Baja, who is the plaintiff's party opponent. Therefore, this is an exception to hearsay.
Right. So I think that if the father heard, "I'll kill you," but I guess this might be an 805 objection, which is maybe the father heard it from Karen Baja, which is the admission by a party opponent, but then the father telling the son is a layer of hearsay. But I do think that's an 8033, so I'm going to let you proceed. Overruled. Go on.
Did your father ever get the restraining order he filed for?
He did not. Unfortunately, the court denied the restraining order.
After that restraining order was denied, do you recall any other arguments your father had with the defendant?
There was one that really stuck out to me. It was about a month and a half after the restraining order was denied, and about 2 weeks before the last time I saw my dad.
And what happened during that argument?
We were all at work, we were all in the office, and I heard my dad bring up wanting to get divorced again. Karen started yelling and screaming. She stormed out of my dad's office. She seemed furious over it.
Did your father respond?
Yeah, after that argument, he walked out and he was visibly shaken. I mean, I'd never seen him look scared like that before, and this is a guy who works with tigers. I asked him if he was okay. He said, "If anything ever happens to me, be sure to have the police look into Karen, because she will be the one responsible for my death."
Objection, Your Honor. Hearsay.
What's your response, Ms. D'Amelio, to that statement?
Your Honor, this is an exception to hearsay under Rule 8032. It's an excited utterance by Lou Donaldson. The witness has just testified that his father was in a heated argument with the defendant where she was yelling, seemed furious, screaming. Therefore, that constitutes a startling event, which gave rise to an excited utterance.
Okay. Yeah, except for the statement itself is not about the thing he's excited about. When for 8032, if someone says something like, "If something happens to me in the future, you should look at Karen," that's not about the argument they were having. So I have a hard time admitting it under excited utterance. Do you have another hearsay exception that you can think of?
Your Honor, it also falls under Rule 8033, which is Lou Donaldson's state of mind. It goes to show that at the time he had that argument with the defendant, he felt that he was in danger.
Under those grounds, I will let it in, and the objection is overruled. You may proceed.
How did you feel when your father said that to you?
I mean, between the arguing and the attempt at getting a TRO, and then after he told me to have the police look into Karen if anything ever happened to him, it seemed like my dad thought Karen might have wanted to murder him.
I'd like to discuss that a little bit. Specifically, why you think your father's disappearance was actually a murder. When was the last time you saw your father?
It was August 17th. We were at the office. It was a Friday. We were packing up, and he told me he would see me at work on Monday. He invited me for dinner on Sunday, but August 17th, 2012 ended up being the last day I ever saw him.
After that, did you ever try to figure out where your father went?
I mean, of course I did. His son, as his assistant, I kept track of all of his financial records and I looked at them just to see what was going on. And there was some stuff in there that didn't make any sense to me.
Would you recognize your father's financial records if you were to see them today?
I would, yes.
Would you please open page 54 of your case packet to the document labeled base number 0015 and let me know when you're there.
Yeah, I'm there.
What is that?
This looks like a copy of my dad's bank statement. It's dated from August of 2012 up through September of 2017.
Does it appear to be in the same condition as it was the last time you saw it?
Yep, it looks exactly like it did back then.
Plaintiff moves Lou Donaldson's financial records into evidence. It's for reference, it's the document on page 54 of the case packet, base number 0015. This would be Plaintiff's Exhibit 1.
Thank you. Any objection, Ms. Noor Mohammadi?
None, Your Honor.
All right, this should be admitted as Plaintiff's Exhibit 1.
Permission to have my co-counsel publish the exhibit to the jury by sharing her screen?
Granted. And moving forward in the trial for both sides, I know that this is great to ask for permission. It shows poise, but I think that you can just assume any exhibit that's been published, you may share your screen without asking me.
Thank you, Your Honor.
You're welcome.
Now, Mr. Donaldson, what doesn't make sense about these financial records?
So if you look at it on the last day that I saw my dad, on the 17th of August in 2012, he spent just around $940 on some animal supplies. Then that money was never touched again after that, even though there was nearly 100 grand left in that account.
Now, I'd like to talk about whether or not it's possible that your father is still alive. Do you think it's possible that he's alive and living in Costa Rica or anywhere else?
Objection, Your Honor. Calls for speculation, improper opinion.
Response.
Your Honor, the witness is simply going to testify to his rationally based perception. If I may proffer,
Sure.
he'll testify to the fact that he spoke to his father almost every day. His father would always let him know when he was taking flight and where he was going. And so the witness has a rational foundation on which to lay an opinion that his father would have contacted him if in fact he was still alive.
So, Ms. DiMiglio, your response is exactly the foundation that I would need in order for me to allow you to ask that question. So while that sounds like a great chapter heading type question, unfortunately, it is a question that lacks a lot of foundation that I would need. If you ask him all those questions and he establishes that he regularly talks to his father and knows his routine and blah, 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 then I think that that question may be fair at the end, but I can't let you ask it right now.
Yes, Your Honor. Mr. Donaldson, how often did you speak to your father?
I mean, just about every day when he'd come into the office, over the weekends, obviously, when I'd go to visit. And then if he ended up going off on a business trip or anything like that, he wouldn't go more than a couple days without contacting me at any point.
And were you familiar with his schedule?
Yeah, I mean, as I was his assistant, so I was in charge of scheduling all his meetings and making sure that everything was booked and good to go.
Were you familiar with the flights that your father took?
He would tell me anytime he was going to fly anywhere. So I would say that I was pretty familiar with any time he was flying.
Do you think it's possible that your father flew to Costa Rica or anywhere else without telling you?
No, I just don't think it could be possible. I mean, I'd see him all the time before that. He'd always tell me before he flew. I would manage his schedule and his bank records. I just can't see how he would have gone off without telling me.
Do you think it's possible that your father attempted to fly to Costa Rica on August 17th, 2012?
No, I don't think it was possible.
Why not?
Well, besides him always telling me before he would fly anywhere, when they finally found his van, they found his glasses in there. And ever since I was in high school, he'd only ever owned that one pair of glasses. He was attached to them like he was some sentimental, but he was blind as a bat without them. And I just don't think he could have taken off in an airplane without the one pair of glasses I'd only ever seen him wear.
Now, after the last time you saw your father, how did you discover that he was missing?
The first time that I suspected something might be up was actually that Sunday after August 17th, about 2 days after I last saw him. Around 6 in the morning, I got a notification that the alarm went off down at Wild Wildlife. I immediately ran into my car and drove off, and the whole time I had this terrible feeling in the pit of my stomach.
What did you find when you got to Wild Wildlife?
So I walked up to the front gate where we keep a padlock to keep the gate closed and locked up. And that padlock had been cut and broken. I went in and I started walking around to the back, and the back entrance to the office was completely ruined.
Did you call the police?
No, I didn't call the police because our security system is set up to automatically notify the police anytime I get notified when it goes off. At the time that I drove in, they drove in right behind me, and so they were with me as we were going into the office. And we were about to go in when Karen walked out with some man I'd never seen before.
Do you know when the defendant got to Wild Wildlife that day?
I don't know for sure when she got there, but she was there when I arrived, so she probably got there before I did. The man that was with her, he was carrying lock cutters in his hands, and in her hands she had a lockbox that I kept locked in the bottom drawer of my desk.
And what did you keep in that lockbox?
The only thing I had in there was my dad's last will and testament.
Did the defendant say anything to you or the police?
Karen, when she
No.
walked up,
For hearsay?
Response?
Your Honor, this is a statement by a party opponent, so it is an exception to hearsay.
All right. Based on the 801 D2A exception or exemption to hearsay, I will overrule that objection. Go on.
What did the defendant say to you or the police that day?
Well, when she walked out holding the lockbox, she was smiling from ear to ear, and then she told the police that she was the owner of Wild Wildlife now. They should contact her attorney if they had any questions. I just couldn't believe it.
Why couldn't you believe it?
I had no idea that my dad was any kind of missing before then. I mean, right before he left on Friday, he told me that I'd see him at work on Monday. But 2 days right after he had been seen alive, Karen was walking out of that broken into office with a lockbox where my dad kept his will.
After the defendant took over ownership of Wild Wildlife, did you continue to work there?
No, Karen kicked me out of the business.
And did anything else the defendant did at that time stick out to you?
Yeah, about a week after all this had happened, she went to pick up my dad's van. That's when we found his glasses and his keys were still on the seat. And that's when I started to figure that I might never get to see my dad again, that he might never come back.
And how did you react to the news that your dad was probably never coming back?
I mean, I haven't exactly reacted well. I feel like I haven't even been able to properly mourn for my dad because of everything that's been going on these past few years, especially with Karen.
Now, I'd like to talk about what that mourning process was like for you, Mr. Donaldson. After the defendant left with the lockbox, what happened to your father's will?
I don't know what happened to the real will.
what do you mean, real will?
The will that I kept in my lockbox, the one that my dad had drawn up years before, it split his assets up 4 ways. I'd get a quarter, my mom would have gotten a quarter, Karen herself would have gotten a quarter, and then the last quarter would have gone to Wild Wildlife as a business.
And how did the new will, the one the defendant had, divide up your father's assets?
Everything went to Karen.
Why do you think that your father didn't write that will?
Objection, Your Honor. Speculation.
Response?
Your Honor, the witness, if I may proffer,
Sure.
the witness is going to testify that based on everything he knew of his father, based on his access to the prior will and what it contains, the fact that it divided up his assets 4 ways, the new will was different. It gave everything only to the defendant. He'll also testify that the will contains some unusual language that he had never seen before in his father's will, which led him to rationally base his perception that he didn't believe his father created that will.
Your Honor, may I respond to that real quickly?
Yes.
Specifically in regards to any testimony about Cam Donaldson mentioning strange language like if I die or disappear, I'd like to raise an improper opinion to any testimony that he may provide about the language die or disappear.
Miss Demiglio, you're not going to like this, but I do agree with Miss Noor Mohammadi that this is an improper lay opinion in violation of 701, 702. I can't have this witness testify to whether this will was forged. It's just not a thing. I think that if he knows that this will was forged somehow, then maybe we can address that. But I'm going to have to sustain that objection based on what I know thus far.
Yes, Your Honor. Do you know when your father's life insurance was paid out?
I do. So he was considered officially missing and nobody could find my dad's body. So they had to wait 5 years to be able to have him declared legally dead. Karen went to the
Your
court.
Honor, improper legal opinion, lack of foundation, specifically in regards to the statement they had to wait 5 years to legally declare him dead. There's no foundation that has been laid that Mr. Donaldson would know any information about the procedure of legally filing someone dead, and therefore he lacks the proper legal opinion.
May I respond?
Yes.
Your Honor, this witness is not offering any legal opinions. He's simply stating what happened in this case with his father. He's already testified that he was extremely close to his father. He was involved in the process of finding and understanding his father's will. He has knowledge about the life insurance policy and when it was paid out. Thus, he's just stating that in his father's case, they had to wait 5 years to have him legally declared dead. He's not making any legal opinions about what would happen in any other case. He's simply stating what did happen in this case.
And Miss Noor Mohammadi, while I normally agree that sometimes an opinion on an ultimate issue may be problematic under Federal Rule of Evidence 704, I don't think that it is as problematic for a layperson as a non-expert to opine on a fact that just so happens to be an ultimate issue. I don't even think this is an ultimate issue in this case. So I'm going to give her a little leeway, though I think it is on the edge. For that reason, I'm going to overrule the objection, and you may proceed.
Do you know when your father's life insurance was paid out?
Yeah, so like I was saying, they had to wait 5 years since he was officially considered missing. 5 years to the day.
It appears I'm not sure if we lost our judge.
I think we did.
Seems as though we have lost Her Honor.
Hey guys, I don't know what happened. Zoom kicked me out there for a second. I apologize. I'm so glad that you're all in there. I thought we're going to have to start this whole thing again. Is everyone who we want to be in the participants room still in the participants room? All my advocates are here, witnesses here. Great. I don't know what happened. I apologize. Ms. DiMiglio, I think you were on a question right after I overruled an objection on the ultimate issue. And so if you could please pick up there, and I apologize for the interruption.
Yes, that's perfectly fine. Do you know when your father's life insurance was paid out?
Yeah, so since he was officially considered missing and nobody could find his body, they had to wait 5 years to have him declared legally dead. 5 years to the day after my dad, quote unquote, disappeared, Karen went to the courthouse to have him declared legally dead. And she filed to have that life insurance policy paid out that exact same day.
In addition to the business and the life insurance policy, did the defendant take anything else?
Karen took my dad from me, one of the greatest men I ever knew. I mean, he was a hard worker my whole life. He started off with almost nothing, bought and sold used cars, made a ton of money so that he could pursue his real passion, and opened Wild Wildlife so he could work with animals.
What was he like as a father?
He was the best. He taught me everything I learned about hard work, gave me that amazing opportunity to be his assistant. And
finally, sorry, continue.
He built this amazing business, and I hope that one day I could take it over and continue his legacy.
And finally, Mr. Donaldson, how did losing your father affect you?
It's like I've lost a part of me. My dad never got the chance to see me grow up, see me become a real adult, never got the chance to meet his grandkids. I'm never going to get to ask him for parenting advice or invite him over for weekend barbecues. I just miss him.
Thank you, Mr. Donaldson. Your Honor, I have no further questions at this time.
I'm just turning my video off so that I make sure I don't get kicked off again because of the internet connectivity. Ms. Noor Mohammadi, if you can please proceed with your cross. I'll turn my video on and unmute if there's an objection.
Yes, Your Honor. Mr. Donaldson, I know this might be hard, but I need to ask you some questions about your father. Now, in addition to being a businessman, your father was a pilot?
He was. I always thought he was a pretty good one.
He owned multiple planes.
He did.
And months before his disappearance, he had a suspended pilot's license.
Yeah, he always told me that he'd tell me the story one day, but...
And that's why he had a tendency to fly without logging flight plans with any of the local airports.
Objection, improper character evidence.
Response to improper character evidence.
Your Honor, I can rephrase my question.
Okay.
Motion to strike that question, Your Honor.
I think since the witness hasn't responded, we'll just proceed.
Yes, Your Honor.
Mr. Donaldson, your father sometimes flew without logging flight plans with any of the local airports.
Yeah, he would fly without logging any plans, but he'd always tell me.
Now, you don't know how many planes your father owned.
No, I don't think anybody ever really did.
But you do know that some of his planes weren't registered?
Yes,
Now, August 17th, 2012 was the last day you saw your father.
it was.
And on direct, you shared how much you miss him.
That's right.
On direct, you said that you spoke to him every single day.
I mean, just about.
On direct, you shared that you were so familiar with his schedule
Yeah.
and that you felt like he was a part of you.
I mean, yeah.
But after he was identified missing, you didn't try to look for your father.
I just hope the police were doing their job.
But the answer to my question is no. After he wasn't identified as missing, you didn't try to look for your father.
No, I didn't. I figured that's what the police were for.
You didn't try to call him.
No,
You didn't try to text him.
no,
You didn't try to look for any recent reports of plane crashes in the area.
no, I guess I didn't.
You didn't try to determine if one of your father's planes was missing.
I mean, I didn't really know how many planes he would have had, so I wouldn't have known where to even start looking for that.
So you didn't try to look for any of his planes that may be missing.
I mean, I guess not.
But you did, however, hire a private investigator.
I did. I figured Karen might try something, so I wanted to make sure that there was somebody keeping an eye on it.
Now, you hired a private investigator in 2017.
Yeah,
And in 2017, you discovered that Karen Baja got the $5 million life insurance policy.
I figured that she might be trying to get her hands on it, yeah.
Now, you gave a testimony in a prior deposition in this matter, correct?
Yes,
And at that time, you were asked questions and you answered them.
I did.
And before you testified, you were asked to raise your right hand and swear to tell the truth.
Yes,
And you did tell the truth.
I did.
And and in your testimony at the prior deposition, you gave a full and complete statement of everything that happened.
Well, I answered whatever questions I was asked.
Referring court and counsel. Just one moment, Your Honor. Referring court and counsel to page 23, which is the beginning of Mr. Donaldson's deposition. Mr. Donaldson, isn't it true that nowhere in your testimony in your prior deposition did you ever state that Karen Baja had an obsession with cats?
I don't know if I was asked about her obsession with cats in my deposition.
But the answer to my question is no, you never mentioned anything about any obsession with Miss Karen Baja's obsession with cats.
I mean, I didn't. I would have told the attorneys if they had asked me.
And you never mentioned in your prior deposition that you had a pit in your stomach when the alarm went off August 18th.
And I think I mentioned that I was feeling pretty bad about it.
But you didn't mention that you had a pit in your stomach right when the alarm went off.
I mean, hasn't having a pit in your stomach feeling pretty bad about something?
But the answer to my question is yes. You never mentioned you had a pit in your stomach.
Maybe I didn't use those words.
And isn't it true that nowhere in your testimony, in your prior deposition, did you ever state that the reason your father let you run the business was because he was on business trips?
I was never asked in my deposition why.
So you're here today offering a brand new opinion, correct?
I was answering the questions that were asked me today, just like I did back then.
I understand, Mr. Donaldson, but my question is, you're here today offering brand new opinion testimony, correct?
To a brand new question, I guess.
Let's move on. Now you're the plaintiff in this matter,
I am.
and you're challenging Mr. Donaldson's last will and testament.
Yeah, that is part of this.
But you didn't bring a lawsuit in probate court.
No, I didn't.
And you're challenging Ms. Baja's receipt of the $5 million life insurance policy.
Yeah, I want her held accountable.
But you didn't file a lawsuit against the insurance company.
No, I didn't.
Here, instead, you brought a wrongful death lawsuit.
Yeah, because I think Karen killed my dad.
I understand that's what you're claiming, Mr. Donaldson, but you never saw Karen Baja kill your father, correct?
I mean, no, I didn't see it with my own eyes.
And you never saw Karen Baja even harm your father.
I mean, I guess not. I only have the argument and what my dad told me.
And you've never spoken with anyone who's seen Karen Baja kill your father.
No, I guess she was able to do it without any witnesses.
And you haven't spoken with anyone who's seen Karen Baja even harm your father.
No, I guess not.
Now, I'd like to talk to you about your relationship with Miss Baja. Miss Baja is not a recent acquaintance, correct?
No, she's my wicked stepmother.
Now, you met Miss Baja after your father was seeing her.
Yes.
And when your father met her, he left your mother, correct?
Objection relevant?
Response?
Your Honor, it is the defense theory of the case that Mr. Donaldson has a strong bias against Karen Baja and that he's never liked her, which is the reason why he's bringing this lawsuit today.
I think that's somewhat relevant. I'll overrule. Continue.
Now, after your father met Miss Baja, he left your mother.
I mean, yeah,
Then he married Miss Baja.
he did.
And as you mentioned, making Miss Baja your stepmom.
Yes.
And you've never liked Miss Baja, have you?
No, I guess I never was a big fan of her.
In your own words, you hate her.
Objection hearsay?
Response?
Your Honor, may I have a moment?
Absolutely.
Your Honor, this goes to the plaintiff's state of mind and how he feels about Miss Baja.
All right, that's fine. I also, if you want to introduce it substantively, I think that may work under that exception. I think it sounds to me the reason you're using it for is not even for the truth of the matter asserted. So it would be not hearsay. It would rather be for the witness's credibility to show bias. But of course, I think you provided me a somewhat arguably sound exception to hearsay. So if you want to use it substantively, you can. But if you want, you can just also use it for impeachment purposes. So you may proceed. That'll be overruled.
Yes, Your Honor. In your own words, you hate her.
Yeah.
Now you're challenging the last will and testament Miss Baja presented to probate court.
Yeah, I think I mentioned that. I am.
But according to you, there was a prior will.
Yeah, there was the one I kept in my lockbox.
But you didn't bring any copies of that will.
There was only one copy, and Karen must have gotten rid of it when she took the lockbox.
Now, so we're just going to have to take your word that a prior will existed.
I guess.
Now, you stated that that prior will split your father's assets 4 ways.
Yeah, it was gonna go a quarter to me, a quarter to my mom, a quarter back to Karen, and then a quarter back to the company.
But today you're not just asking for 25% of your father's assets.
No, I'm not.
Today you want it all.
I mean, I don't want Karen to be able to profit off murdering my dad.
But the answer to my question is yes. Today you do want it all.
Yeah, I want to be able to take care of my mom and take care of the company.
No further questions, Your Honor.
Thank you, ma'am. And do we have a redirect?
No redirect, Your Honor. We ask that Mr. Donaldson be excused.
All right, Mr. Donaldson, you may be excused at this time, subject to recall, which I'm assuming are not part of the local rules. So I think you might be excused. Plaintiff, please call your next witness. And I think if we can have a time check as well, I think that would be a good idea.
Yes, Your Honor, just give us a moment to add up those times.
Sure, and you can give us the time after the cross-examination of this witness is done. I think that might be the best time to do it, but maybe start adding up the times.
Of course.
Ms. Morris, all you.
Yes, the plaintiff calls Taylor Pride.
All right, Ms. Pride, you have been previously sworn in, and Ms. Morris, your witness.
Good evening. Would you please state your name for the jury?
Yes, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I'm a private investigator.
How long have you been a private investigator?
I've been a private investigator for about 4 years.
And why are you here today?
Well, I was hired by the plaintiff to investigate the disappearance of Mr. Lou Donaldson, as well as the authenticity of his last will and testament.
Now, before we get into the details of this case, I'd just like to talk a little bit more about your background. Prior to the 4 years that you've spent as a private investigator, what did you do before then?
Well, I was a detective with the Pioneer Police Department.
And when did you become a detective with the Pioneer Police Department?
2000.
When you were a detective, did you focus on any particular area of crime?
No, I actually was able to focus on a wide array of areas of crime, anything from economic crimes all the way to murder.
Do you have experience investigating forgeries?
I do. During my time with the Pioneer Police Department, I was assigned to the Economic Crime Unit. I was there for a few years, and while there, I spent a lot of time investigating forgeries.
Does the investigation of forgeries require any specific training?
It does.
Can you tell us a little bit about that training?
Of course. I attended a 2-week seminar to learn how to analyze and compare different handwriting samples, and then I became board certified.
Do you have to keep up to date on this training?
I do.
How do you keep up to date?
I attend an annual 8-hour course that's provided by our certifying board. I stay up to date on current literature, and then I recertify with the board every 4 years.
Have you testified as an expert witness before?
I have 15 times.
And which side did you testify for?
I testified on both sides.
Was it criminal or civil?
Both.
Now, when you turn to this investigation, can you tell us a bit about the methods and sources that you relied upon?
Of course. So what I do when I do any sort of investigation is I conduct personal interviews with any relevant witnesses. I look at any documents, and then I would conduct a forensic document examination, that sort of thing.
And are these methods standard to the fields of private investigation and forensic document examination?
They are.
And did you apply these methods reliably to the facts of this case?
I did.
Your Honor, at this time, plaintiff tenders Taylor Pride as an expert in private investigation and in forensic document examination pursuant to Rule 702. Oh, Your Honor, I think you're on mute.
Thank you. You said private investigation and forensic document investigation?
Forensic document examination.
Examination, okay. Ms. Reed, do you wish to voir dire or object to the tender and the scope?
No
Or the-
objection. No objection. Your Honor.
Excellent. Feel free to object if the witness goes beyond the scope of her tender. Ms. Morris, your witness.
Now, Ms. Pride, let's talk about this case. When did Lou Donaldson go missing?
He disappeared back in 2012.
And when he disappeared, did the local authorities investigate?
Yes, the Pioneer Sheriff's Department has been investigating since 2012.
Is this investigation ongoing?
It is, and as a result of that, the police department has actually been very reluctant to release a lot of information about the case.
In your opinion, Ms. Pride, what do you think about this investigation?
I don't believe that the Pioneer Sheriff's Department did a very thorough job
Objection.
investigating.
Improper expert opinion lacks foundation.
Response?
Your Honor, may we approach on this matter as well?
Yes. So response, Ms. Morris, on the improper expert opinion, which I'm assuming is beyond the scope of her tender for this opinion?
Yes, certainly, Your Honor. Ms. Pride has just testified that she spent over 20 years in law enforcement, previously as a detective with the Pioneer Police Department, and now 4 years as a private investigator. She also testified that she looked at the sheriff's report to the extent that it was available, given that it's an ongoing investigation. This is plenty to tender an expert opinion on how she believes the quality of the sheriff's investigation has gone.
Ms. Reed?
Yes, Your Honor. No one here can testify as to what this police investigation included, including the witness on the stand. And as an offer of proof, this investigation, as opposing counsel has mentioned, is still ongoing. Therefore, she lacks any foundation or personal knowledge to talk about the quality of the investigation, and allowing her to do so would mislead the jury into believing that she knows how the investigation was conducted when the evidence is to the contrary, because as we know, the investigation is still ongoing. And because it's still ongoing, as an offer of proof, information has not fully been released as to the contents of this investigation.
So, Ms. Morris, I tend to agree a little bit that I'm not sure how a witness is qualified to opine on the sufficiency or efficacy or validity of a police investigation when they are an expert in her scope. So help me understand that a little bit. Why is it that she can say the police did not do a thorough investigation or they did do a thorough investigation?
Yes, Your Honor. Ms. Pride spent 20 years as a detective with the Pioneer Police Department conducting investigations like these of her own. That time she spent investigating, as she testified, every type of crime from murder to economic crime and everything in between. So that experience alone should qualify her to give an opinion on an ongoing investigation that she's been able to observe from the distance that she's been able to. Again, they've limited the information available. Additionally, if I may proffer, Ms. Pride will give a reason why she thinks this is a lackluster investigation.
I think my only issue is that she wasn't tendered as an expert in criminal investigations. Having said that, I am going to give you a little bit of leeway. I do think that you are on a little bit of a tight leash here. Ms. Reed, I encourage you to object again if this goes a little too far. I'm going to give you a little bit of leeway to explore the reasons for why she's saying this is not a good investigation. But I can't have her toss out the investigation or make such strong conclusory opinions about the investigation, because I don't think that was part of her tender. So I'll let you proceed. Ms. Reed, feel free to re-object if there's something that pushes the line again, okay? All right, go ahead, Ms. Morris, your witness.
Ms. Pride, in your opinion, why was this investigation lacking?
Well, I believe this should have been investigated as a murder.
Why do you believe it should have been investigated as a murder?
There's significant evidence that Ms. Bagia killed her husband.
Let's talk about that evidence. What evidence exists to support that theory?
Well, starting with, there's the temporary restraining order that was sought by Mr. Donaldson against Ms. Bagia.
Objection, Your Honor. May we approach on a pretrial
Sure.
matter?
Yes.
Your Honor, the defense objects on inadmissible hearsay, character evidence, and unduly prejudicial under 403.
Okay. I think that Mr. Donaldson already referenced the temporary restraining order and the fact that it was sought. I'm not sure that it was admitted into evidence. In fact, I know it wasn't. So Ms. Morris, please explain to me how and why this witness can talk about the contents of the temporary restraining order. And let's take it up now.
Certainly, Your Honor. If I may proffer, I was going to admit the temporary restraining order with Ms. Pride. If I may proceed to do that, or I can make the arguments at the sidebar, whichever you prefer.
Why don't you go ahead and publish the temporary restraining order as if we were at the bench? I'm a ruling judge. Both of you are there. Jury's not seeing. Let's put it up on the screen and let's talk about it so we can actually figure out which parts we're admitting, all of it, none of it, or anything to that effect. So go ahead and provide me your argument as to why this should be admitted. I personally think this is probably the biggest piece of evidence in the case evidentiary argument wise. So go ahead and provide me your argument.
Sure. So the existence of the temporary restraining order as a document itself in the world falls under the public record exception of 8038. The document, as you can see, sets out the office's purpose. It's marked as the district court in this jurisdiction, I might add, with a case number and a denied stamp, which shows that this was in front of a judge. So that sets out the office's purpose. Moreover, it's a matter observed while under a legal duty. Again, the case number provides that this is an official court document. In addition to that, the contents within the temporary restraining order, as you mentioned, Your Honor, have already been established as 8033 exceptions. These describe Lou Donaldson's state of mind. Finally, regarding the improper character evidence, this falls under 404B2 because it speaks not to a particular character trait of Ms. Bagia, but a very specific situation that actually explains her motive. The prospect of a divorce followed by a death threat, it's not a character trait. This was a specific situation that very clearly establishes a motive and is highly relevant to Lou Donaldson's disappearance just a short while later.
Response?
Your Honor, even if these do fall under the exception to the hearsay rule, which this is not a public, this does not qualify as a public record, we have no witness who can authenticate this and lay the foundation for this being a public record. Therefore, it does not fall underneath that exception of 8038 or 80310 to the hearsay rule. Additionally, there is still the matter of the propensity evidence, because the fact is that the jury, regardless of what purpose opposing counsel intends to offer this for, will see this document that says that Karen Bagia, the defendant, has threatened to kill me. They will then take this document and use it for the improper character purpose of assuming that because she had allegedly a violent propensity on this occasion, that she acted in accordance with that same behavior on prior occasions.
Your Honor, if I may respond briefly.
Yes, and in your response, you can address Ms. Reed's arguments if you wish, of course, but I guess let's just cut to the chase. Here's what I'm trying to figure out, Ms. Morris. Why do you need this? What is it that you are introducing this for? Like truly, why do you need this? Are you showing this to show that this guy was scared of Miss Bagia, or excuse me, the alleged victim was scared of Miss Bagia before his death? Is that the purpose? Because if that's the purpose, we already established that. What is the purpose for why you're introducing this for? Because that's going to help me with my ruling. So please respond to Ms. Reed's argument if you wish, but also help me understand what is the purpose for why you're introducing this.
Yes, Your Honor. With just a quick response to the response to the public records. This is, as I said, it falls under 8038, which does not require a custodian. 8038 lays out two requirements, which I discussed, and this document fulfills. It's not a business record or a record of regularly conducted conduct, which does require a custodian. Now, to your question, Your Honor, as I said, this of course, it speaks to the fact that Lou Donaldson was afraid for his life, if I may offer, but it also speaks to Karen Baja's motive, which is permitted under 404B2, a motive that is stated right here, a threat to kill. This, as my co-counsel noted, is a wrongful death suit. So the fact that the defendant in this suit had made death threats that were recorded in a court of law, because Lou Donaldson felt the need to take this extreme remedy, is relevant and falls under 404B2. It speaks to her motive.
I think that's an excellent argument, Ms. Morris, but the two seminal cases I'm thinking about, not to get too nerdy about the law, that talk about motive are not exactly that. I don't think this goes to motive. I'm having a hard time admitting the contents of the temporary restraining order unless you can come up with a reason that the contents should be admitted. Having said that, the fact that a temporary restraining order was sought has already come in. So we can't unring the bell. And I think this witness can easily talk about the fact that the alleged victim sought a temporary restraining order against the defendant, just like Mr. Cam Donaldson testified to. I'm having a hard time letting you admit this restraining order in based on what I've heard so far. And so I'm going to have to sustain the objection. You can continue to ask your witness about the fact that there's a temporary restraining order. You cannot ask her what it says line for line, word for word. And I'm not going to be able to let you admit this in and send it to the jury. So let's proceed. If something else comes up, feel free to try and admit it again, because I can arguably see ways that this could come in. So that'll be sustained for now.
Thank you, Your Honor. Ms. Pride, in your opinion, what does it mean to seek a temporary restraining order? Oh, Ms. Pride.
For opinion.
I'm going to give her a little bit of leeway on that question, so I'll overrule it. Feel free to re-object if it goes too far. Go ahead, Ms. Morris.
In your opinion, Ms. Pride, what does it mean when someone seeks a temporary restraining order?
Well, typically when one seeks a restraining order, there's some basis for the restraining order. And whether or not a judge or magistrate would grant that restraining order is a separate issue.
Now, moving on from the restraining order, was there any other evidence to suggest that Ms. Baja murdered her husband?
Yes, she had a significant financial motive.
Can you tell us more about this financial motive?
Of course, it was laid out in Mr. Donaldson's last will and testament that was produced by Ms. Baja.
How did you come across this will and testament, Ms. Pride?
I gained access to it through Chris Renard, who was the life insurance investigator in this case.
And Ms. Pride, if you wouldn't mind turning to page 53 of your trial packet and let me know when you get there.
Of course. All right.
What are you looking at, Ms. Pride?
This is that last will and testament.
And is it in the same condition that it was when you looked at it during your investigation?
It is.
At this time, Your Honor, plaintiff moves to admit what's been previously marked 0014 as plaintiff's exhibit 2.
And this is the will?
Yes, Your Honor, this is the alleged last will and testament that's at issue in this case.
Certainly, thank you. Ms. Reed, any objection?
No objections, Your Honor.
All right, that shall be received as plaintiff's exhibit 2, and you can publish.
Ms. Pride, did you look over this will as part of your investigation?
I did.
And did anything stand out to you about it?
Yes, two things stood out to me about it. First was the language that was used in the body of the will, and then the second was the signature at the bottom, specifically Mr. Donaldson's signature.
Let's take those one by one, starting with the language. What stood out to you about the language?
Specifically, the words die or disappear stood out to me.
Is this notable?
It is.
Why?
Well, I have never once seen the term disappear in a will before.
You've never seen the term disappear before. How many wills have you examined over the course of your career?
Hundreds.
And you've never seen this term before?
That's correct.
Now, I'd like to move to the signature of this will. Your Honor, may I share my screen with a demonstrative?
Yes.
Objection. Your Honor, may we approach on the issue of
Yes.
this demonstrative?
Yes.
Or
What is
actually,
it?
withdrawn, Your Honor. Withdrawn.
Okay. And so are you, Ms. Reed, just to be clear, are you fine with Ms. Morris sharing her screen with whatever demonstrative she's about to share?
Yes, Your Honor.
Okay, Ms. Morris, please go ahead.
Ms. Pride, first, can you tell us a little bit about how you went about analyzing these two signatures? I think you're on mute, Ms. Pride.
I keep muting myself during the objection so I don't accidentally say anything. So as I was saying while I was muted, there are several steps to doing a forensic document examination. The first step of that is to obtain known samples of the signature of the signatory to essentially compare those signatures.
And did you collect these signatures from Mr. Donaldson?
I did. I was able to collect one from his driver's license and then one from the restraining order paperwork.
And we've talked about the this process. What do you do next?
So after getting those signatures, getting those samples, I start to compare them to the signature in question. You start to look at the different handwriting characteristics. These are things like shapes, angles, the weight and height of different letters, which letters are capitalized, and a number of other things.
So let's turn to these samples at hand. What did you observe about the samples from Lou Donaldson?
Of course. So starting with Lou, out of the Lou Donaldson, you can see that the O in there has only one loop in the interior.
Your Honor, may we approach?
Yes.
Your Honor, the defense has no objection to the use of a demonstrative. However, because the temporary restraining order has been kept out, we do object to the use of this sample of the handwriting in the plaintiff's demonstrative.
Response, Ms. Morris.
Yes, Your Honor. Both of these signatures were relied upon by the life insurance expert, Chris Renard, in addition to Ms. Pride. I'd be happy to introduce both in that capacity following the demonstrative. This in no way speaks to the validity or contents of the temporary restraining order, which we've already established, simply the signature on the document. If I may, I can introduce both following this demonstrative.
I think it is absolutely fair to take a legal document that the victim, alleged victim, has signed and take the signature for comparison in order to establish the validity of the signature. And so although the temporary restraining order itself has not been admitted, what I will order is that the temporary restraining order, at least thus far, the signature of the temporary restraining order has been admitted for the purposes of an expert analysis into the signature comparison. So great objection, Ms. Reed, great catching that, but I am going to have to overrule it because this does not go to my concerns about why a temporary restraining order should be kept out. So Ms. Morris, you may proceed with the comparison of the TRO signature and the driver's license signature.
Thank you, Your Honor. Ms. Pride, would you mind repeating what you noticed about this O in Lou?
Of course. So as you can see in that O, there's only one loop on the inside of that.
Did you notice anything else about these two samples?
Yes. In the second O, so that's the one that's the second O in Donaldson, You can see that that O is what we call a lazy letter. That's something that when someone's writing kind of towards the end of the signature, it gets a little lazier.
And did you notice anything else about the samples?
Yes, finally, what you can tell from the samples is that the signature barely lifts the pen in both of those samples. It's one continuous line. This was most striking to me.
Were you able to form an expert opinion about these two samples?
I was, yes.
What was that opinion?
That those signatures, the one from the driver's license and the one from the temporary restraining order, were signed by the same person.
I'd like to now move to the will signature. Were you able to come to an expert opinion about the will signature?
No. Oh, excuse me. Yes, I was.
And what was that opinion?
It was not the same signature. It was not the same person who signed that.
And why is that, Ms. Pride?
Well, there are three major differences between the will signature and then the two sample signatures from Mr. Donaldson. The first big difference is the D in Donaldson. So what I was able to see is that in the two samples provided, the pen lifts off the paper for just a split second with that D. Looking at the last will and testament D, there's two clear, distinct pen strokes to that.
What was the second observation you made about the differences?
Sorry. The
That's
second
okay.
difference. The second difference that I noted was
I think your dog agrees.
The O in Donaldson. Again, with the two samples provided, we have that lazy O that's in there. However, with the last will and testament, whoever signed that wrote a full second O in Donaldson.
And the third difference?
Yeah, so the third difference that you can see is really the important one. It's that there's quivering lines throughout the entire signature. Basically, what that shows is that the writer of that signature was nervous and writing it slowly. This is something that you see a lot when there's a forgery, because the forger is often looking at that signature to make sure it's copied.
So given all of this, Ms. Pride, what was your ultimate conclusion about the signature on the will?
Of course, given the inconsistencies between the two samples and the will signature, it's my professional opinion that the signature on the last will and testament was forged.
Now, Ms. Pride, you testified that one of the comparisons came from the temporary restraining order and the other came from the driver's license signature. How did you come across this driver's license signature?
Yes, so that was again provided in Mr. Renard's report.
And would you mind turning to page 40 of the trial packet and let me know when you get there?
Of course. Okay.
What are you looking at?
So this is the signature comparison that Mr. Renard did.
And is it in the same condition that it was when you reviewed it?
It is.
At this time, Your Honor, plaintiff moves to enter what's been previously marked Bates number 007 as Exhibit 2.
Any objection, Ms. Reed?
No objections, Your Honor.
Thank you. Ms. Morris, that shall be admitted.
Thank you. I'd now like to turn to a quick discussion of the defense's Costa Rica theory that Lou Donaldson vanished to Costa Rica, never to be seen again. Did you look into this theory over the course of your investigation?
I did, yes.
And in your opinion, what do you think of this theory?
Well, I don't believe that that theory is very plausible.
Why not?
Well, I actually was able to send an employee down to Costa Rica to see if she could track down Mr. Donaldson, kind of to cover our bases to make sure that that was actually done.
And what did she find?
Well, she found basically what we expected to find, that he was not there. My employees searched throughout Costa Rica and did not find a trace of evidence that Mr. Donaldson stepped foot in Costa Rica in August of 2012 or at any point after that.
So given all of this, Ms. Pride, the will and the surrounding circumstances, what is your ultimate opinion on this case?
Yes, it is my professional opinion that Ms. Baggio was responsible for the death of Mr. Donaldson and that Mr. Donaldson's will was forged.
Thank you, Ms. Pride. No further questions at this time.
Thank you, Ms. Morris. Ms. Reed, cross-examination. And after the cross or redirect, I'll ask for a time check for my timekeepers if you can get that prepared. Thank you. Go ahead, Ms. Reed.
Ms. Pride, you were hired as a forensic document examiner, correct?
That's correct.
But you're aware that there was a police investigation conducted by Pioneer County Sheriff's Office.
Yes, I was aware of their investigation.
And this investigation is still active, correct?
That is correct.
And because it's still active, information from that investigation hasn't been released.
Yes, I testified to that on direct.
Now, you weren't personally involved in this investigation.
No, I was not.
You don't know what evidence they collected.
Other than these small little bits that have been released, just kind of general things, no, I don't know the specifics.
You don't know what witnesses they interviewed.
No.
And you don't know what leads they followed.
That is correct.
Okay, let's talk about what you do know. You do know about the will in this case, correct?
Yes.
Ms. Nur Mohammadi, will you please publish what has already been admitted into evidence as Plaintiff's Exhibit 2? Ms. Pride, can you see the screen?
Yes, I can.
Now, it's your opinion that Lou Donaldson didn't sign this will, correct?
Yes, that is my professional opinion.
Because you identified differences between this signature and the signature on prior documents.
That is correct.
But you'd agree that if two signatures were a 100% match, that would indicate that one of those signatures was false.
Yes, it would indicate that the signature had been a direct tracing.
Because no one ever signs the exact same way twice, correct?
That's correct. And as you can see in the two samples, they were not identical either.
Now, there are a variety of reasons you'd agree why a person's signature could be different from one document to another.
Yes, there are a number of factors that could create that difference outside of just a forgery.
For example, a person might be using a different writing utensil.
Yes.
Some pens write more smoothly than others.
Yes. People will have a favorite. Oh, excuse me.
Oh, no, go ahead, Ms. Pride.
Some people would just have a favorite pen and they're more used to it as well.
Some pens have different types of ink.
Yes.
And the amount of care a person takes in signing could also affect their signature, correct?
That is correct.
So someone signing in a rush would sign differently than someone who took their time.
Yes.
And the surface that someone is signing on also affects the signature.
It can.
A document that is signed on a stable surface would look different than a document signed on a shaky surface.
Yes.
But isn't it true that you can't tell us what writing utensil was used for this will, the signature?
No, I cannot.
You can't tell us where this will was signed.
No.
You can't tell us how much time was spent on the signature.
No.
Thank you, Ms. Nur Mohammadi. You can take down the exhibit now. Now, you've been listening to the testimony today and you heard Cam Donaldson testify, correct?
I believe so, yes.
Oh, he testified that his father wore glasses.
I believe so.
And according to him, his father was blind as a bat without those glasses.
I believe that may have been testified to. I'm not quite sure.
But nevertheless, you can't tell us whether or not Lou Donaldson was wearing glasses for any of the signatures you relied upon, correct?
That is correct.
And you can't tell us whether the person who signed this will was also wearing glasses.
No, I have no knowledge of that.
Now, Ms. Pride, you're an investigator.
Yes,
And it's your job to find the truth.
it is.
To do that, you need to review evidence from as many sources as possible.
That is correct.
That includes reviewing documents pertaining to your analysis
Yes,
and interviewing witnesses,
yes,
witnesses who are reliable
yes,
and unbiased.
yes.
But you'd agree that a witness could be biased if they have a significant financial stake in the outcome of an investigation, correct?
That could introduce some bias.
You spoke with Cam Donaldson.
That is correct.
He told you about Lou Donaldson's relationship with Miss Baja.
That is correct.
He told you about an alleged prior will.
Yes,
He told you about Lou Donaldson's disappearance.
that is correct.
But isn't it true that you never spoke with Ms. Baja about her own relationship with her husband?
No, I was not able to talk with Ms. Baja.
You never spoke with her about an alleged prior will.
Again, I was unable to.
So just to be clear, throughout your entire investigation, you never spoke with Ms. Baja at any point, correct?
That is correct.
Now, you never spoke with any other members of the Donaldson family.
That is correct.
You never spoke with any other employees at Wild Wildlife,
I do not believe so.
but you did speak with Cam Donaldson.
Yes, I believe we established that.
And you're aware that Cam Donaldson is challenging Ms. Baja's inheritance of his father's estate,
Yes, I do believe that's why we're all here today.
an estate worth $5 million.
Yes,
He's also challenging the life insurance payout,
yes,
also worth $5 million.
yes,
So you'd agree that Cam Donaldson has a significant financial stake in the outcome of this investigation.
I do.
And to be clear, Cam Donaldson is the one paying your bills today, correct?
Yes, he is the one who has hired me.
No further questions, Your Honor.
Thank you, Ms. Reed. Ms. Morris, is there a redirect?
Just briefly, Your Honor, if I may.
Sure.
Ms. Pride, the defense just listed a number of factors that may lead to differences between one signature and another: writing instrument, surface, etc. Did any of these differences contribute to your ultimate conclusion that this will was forged?
Obviously, those are things that I consider, and just looking in the differences in those writing samples, it is my professional opinion that that signature on the last will and testament was a forgery.
Thank you. No further questions.
Thank you, Ms. Morris, and thank you both for keeping this as succinct as you can. I appreciate that in light of the time limits that you both have. And so why don't we get a time check before we do halftime motions, and then we can go into the defense's case in chief, assuming there are no other witnesses for the plaintiff. So where are we on timing?
Your Honor, I have, with pausing for objections, that the plaintiffs had 27 minutes and 31 seconds remaining, and the defense has 47 minutes and 18 seconds remaining.
Okay. Does either side have a reason to take issue with those times, or are we fine to proceed as we have?
The defense has no issue, Your Honor. We're fine to continue proceeding.
Excellent. Does the plaintiff rest?
No, Your Honor. At this time, the plaintiff would seek to read a portion of Carl Bannister's deposition that was stipulated by party stipulation 4.
Excellent. My apologies for jumping the gun, Ms. Morris. Please go ahead and read whatever you'd like, assuming there's no objection from the other side to the procedure that Ms. Morris is about to follow.
Your Honor, may I request what specific portions of Carl Bannister's deposition will be read?
Absolutely. Ms. Morris, what would you intend to read?
Certainly, Your Honor. I'll give you a moment.
Take your time.
This is found on page 36 of the trial packet. In the middle of the page, it's the third question.
And where does the reading of the statement end?
Just after that answer.
Any objection to those portions, evidentiary-wise, Ms. Noor Mohammadi?
No objection, Your Honor, but in order to give the jury a little bit more context into the statement, we request an additional portion to be read in as well, specifically the question immediately after their answer and then the answer immediately after that. So the question starts with, did you have a chance to view any evidence? And then the answer begins with no.
And Ms. Noor Mohammadi, I'm going to defer to you on the procedure of this. Would you prefer Ms. Morris to read the portions that she wishes to read, as well as the portions that you believe are portions to be read? Or would you prefer that she reads the portions she wishes to read, and then immediately, without any pause, you can read the portions that you think should be read after that?
Your Honor, I have no problem jumping right in right after opposing counsel. So go ahead and read the rest of the portion.
I think that is most comfortable for everyone and clearest for the record, if that's okay with you, Ms. Morris. So why don't you go ahead and start with what you want to read. Ms. Noor Mohammadi, I'm not even going to interrupt. I'm just going to assume you're going to jump right in. Let's get all of the portions that we want read, and then we will not read any more portions, even in your case in chief, Ms. Noor Mohammadi. I'm assuming that anything you want from this deposition or this transcript or whatever it is we're reading from should be read right now. So Ms. Morris, go ahead.
Certainly, Your Honor. Is it okay if my co-counsel reads the answer just for
Sure,
clarity?
and that's
Okay,
fine.
great.
And Ms. Noor Mohammadi, you can do that as well if you would like your co-counsel to read the answer, or you can do it yourself. I'll defer to you.
Question. Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m., as it was showing it was near the grocery store close to Ms. Baj's home during that time?
Answer. Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
Your Honor, my apologies. I actually was looking at the wrong page. I was instructed that it was page 36, not 35 of the record. And so I was looking on a completely different page. I'm not sure. There was a little bit confusion on my end. I heard 36.
Okay.
Apologies. I think I did say 36. I'm so sorry. The PDFs.
That's fine. Ms. Noor Mohammadi, were there portions in addition to what has been read that you would like to read?
Yes, Your Honor. I'll just go ahead and read that specific portion I had mentioned anyway.
Okay.
Did you have a chance to view any evidence or look at the reports? Answer, no. I take my job seriously. I knew nothing of Lou's disappearance, and I wanted to keep it that way. I was walled off from the investigation, and that was fine by me. And that concludes the defense's reading of Carl Bannister's testimony.
Certainly. And of course, Ms. Morris, I'm not in any way being critical of you. These things do happen. But Ms. Noor Mohammadi, is there a record you'd like to make about any objections to the portions that were in fact read? In other words, had you known these were going to be the portions read, would you have objected to them ahead of time? Because let's go ahead and make a record about that to determine whether those objections would have been sustained.
None, Your Honor.
Okay, great. Then in that case, I will accept both portions that have been read by the plaintiff and defense. And at this time, Ms. Morris and Ms. DiMeglio, does the plaintiff rest?
Once again, my apologies, counsel.
These things are going to happen to you so many more times than you would like. I promise you that. I can promise you that right now.
Thank you, Your Honor. Finally, plaintiff would now at this time move to enter the vehicle maintenance report form that Officer Bannister referred to in the deposition we just spoke about.
Any objection to that?
Yes, Your Honor. Lack of foundation.
Yeah, I'm struggling with it, Ms. Morris. I'm sorry. I just don't see how I can enter this in. I just don't have enough foundation about it yet. So tell me if I'm wrong, but I just can't see how this comes in.
We would only submit, Your Honor, that Officer Bannister testified in his deposition under oath that the issue was noted in a maintenance log, and we would simply like to admit that maintenance log about which he spoke in his deposition.
Yeah, I understand that, Ms. Morris, but in almost 100% of criminal trials that you may watch, officers note all sorts of things in logs that will never be admitted or presented to a jury. So I do think the right decision is to exclude this from the jury. I think you did read what you wanted to read, and that is as much as I'm willing to admit for the jury. So that'll be excluded. Ms. Noor Mohammadi, your objection is sustained in that regard. Anything else for the plaintiff?
No, Your Honor, the plaintiff rests.
Okay, great. No more witnesses for the plaintiff. Any halftime motions to present from the defense?
Yes, Your Honor. At this time, the defense would like to make a motion outside the presence of the jury.
Okay.
Your Honor, pursuant to Federal Rule of Civil Procedure 50, the defense moves for judgment as a matter of law. Even after having viewed the evidence in the light most favorable to the non-moving party, the plaintiff has still failed to meet their evidentiary burden on two elements. They failed to prove that Karen Baja did any action, either recklessly or intentionally, to harm Lou Donaldson, and they failed to prove that Karen Baja harmed Cam Donaldson in any way. For those reasons, the defense requests that judgment as a matter of law be granted in the defendant's favor.
Any response from the plaintiff?
Yes, Your Honor. In fact, the plaintiff has proven these elements of our case. If I may begin by asserting that circumstantial evidence is still evidence. First, we heard from several witnesses that the probate court of Statesville had Lou Donaldson declared legally dead. We also heard from Cam Donaldson about how no one has seen or heard from his father, Lou Donaldson, since August 17th, 2012. We saw a copy of his bank records and saw how he hasn't made any transactions since that day. We heard from an expert witness, Taylor Pride, who testified that she conducted extensive investigation into trying to find Lou Donaldson. She even visited Costa Rica, or had one of her employees do so, in attempts to locate him, and could not. She concluded in her expert opinion that Lou Donaldson was deceased. Additionally, we've pointed to many motives and other forms of circumstantial evidence that implicate Karen Baja in Lou Donaldson's death. We've shown how Karen Baja did inherit substantial financial gain after Lou Donaldson's death. She inherited all of his assets valued at $5 million. She inherited a $5 million life insurance policy. We heard from Cam Donaldson how she immediately cut the lock on the office and stole the Lou Donaldson's will. She concluded that she was the owner of Wild Wild Life after Lou Donaldson had been missing for only 2 days. The plaintiff has proven its burden in today's case.
Okay, well, thank you both for the arguments. I think, Ms. Reed, you have stated the standard correctly. Ms. DiMeglio, I think you responded just sufficiently, of course, and I think that I might be kicked off of this if I granted your motion, so we're going to have to deny that. And we will proceed with the defense's case in chief. I normally would like to give everyone a 15-minute break, but I do think we're a little bit behind in where we are in the middle of the trial. That's not on you guys. That may also be on me. I tend to talk a lot during rulings, so I apologize for that. But why don't we just take a 10 if that's okay with everyone? So it's 10:25 right now. Well, I don't know where you guys are time zone wise. It's 10:25 my time. Why don't we take 10 minutes? So we'll just get back at 35 of whatever hour it is. But I would like to start promptly at 35 with the first witness for the defense, and we'll go from there. Does that work for everyone?
Yes, Your Honor.
Okay. So in the meantime, for my scoring jurors and for anyone else, please don't get out of the Zoom meeting. Just go ahead and turn off your video and mute yourself. Please don't get out of the meeting. This way, all you have to do is just turn your, well, you don't have to do video or audio, but just stay in the meeting and we'll just get back into it at 35 after the hour. Thank you, everyone. All right, are we ready?
Yes, Your Honor.
Great. I managed to make some coffee, so I'll be, not that I was not alert before, but I'm more alert now. Okay, defense, unless there's any thing to take up before you start, please call your first witness.
Yes, Your Honor. Your Honor, the defense call Ms. Karen Baja as their first witness.
Okay. Good evening, Ms. Baja. You've previously been sworn in, and so thank you for being here, and Ms. Reed, your witness.
Good evening. Please introduce yourself and tell the court where you're from.
Good evening. My name is Karen Baja, and I'm from right here in Statesville.
Now, I'm going to ask you the question we're all wondering. Did you kill your husband?
Absolutely not.
Ms. Baja, I know this might be difficult, but I want to talk with you a little bit more about your relationship with your husband. How did you and Mr. Donaldson first meet?
Well, he actually rescued me from the side of the road. I was hitchhiking at night, and being my Prince Charming, he picked me up, and it was love at first sight.
What happened after that?
Well, we spent the night together, and after that, we were inseparable. Eventually, we got married.
How long were you and Mr. Donaldson married?
We got married in 2001, so for about 12 years before he left.
And how would you say your marriage was to Mr. Donaldson?
It was good. I mean, no marriage is perfect, but we bonded over our passions and love of the animals.
Now, when you said that your marriage wasn't perfect, what do you mean by that?
Well, there was some infidelity. Lou had a mistress in Costa Rica.
And how did that affect your marriage?
It was something we talked about and were working through before he left.
Now, Ms. Baja, what was your husband like?
He loved the animals. He liked to fly. He was a good businessman. Often he would go to Costa Rica, but he was a more private and secretive person.
Let's talk about the Emporium. You mentioned that you and your husband worked together. So how long did the two of you work together?
We worked together right up until he left, so about 12 years.
When was the last time you saw your husband?
Around August 17th or 18th of 2012.
Do you remember what you were doing that day?
Yes, a tiger had actually just given birth to some cubs a few days before, so I was taking care of them because the mother actually rejected them.
Now, did you notify the police that your husband was missing?
Yes, I did, and they conducted an investigation.
Well, how do you know that?
I spoke to the police during that investigation.
Did you have any idea where your husband could have been?
I believe he went to Costa Rica.
Why do you think that?
Objection, lack of personal knowledge.
Response?
Your Honor, I have a good faith belief that the witness's next answer will establish the foundation and her personal knowledge.
Okay, I'm going to give you a little leeway, and Ms. D'Amiglio, if it doesn't establish it, let's address it, but I do think it sounds like it's about to. So that'll be overruled for now.
Why do you think your husband went to Costa Rica?
Well, like I said before, he had a mistress who lived in Costa Rica. He was also always flying back and forth there all the time, often off radar because he had a suspended license.
Now, at any point,
I renew my objection to lack of personal knowledge.
Okay, and so, Ms. D'Amiglio, are you trying to get at, or excuse me, Ms. Reed, are you trying to get at the fact that Ms. Baja thinks that in this instance, he flew to Costa Rica based on the fact that he regularly flies there?
Yes, Your Honor. It is the defense's theory of the case that Mr. Donaldson left to Costa Rica to be with his mistress. The witness, Ms. Baja, currently on the stand, has already testified that her husband had a mistress. So this is just further corroborating evidence that has already come out in testimony, and also going to our theory of the case to rebut the plaintiff's theory that Ms. Baja killed her husband.
Sure. I do agree. Yes.
Your Honor, then I would amend my objection under Rule 404.
Okay. I do understand that as the defense's theory of the case, you want to argue that he went to Costa Rica. But I've got to agree with Miss DeMiglio a little bit that to have a witness say, I think this is what he did, with no reason to back that up aside from stuff that he's done before, is speculative. Granted, you can argue all you want that he went to Costa Rica based on the evidence you've collected from Ms. Baja in your closing. But I am going to strike that answer from the record that she thinks he went to Costa Rica this time, unless you can establish that he's left her a note, told her, or anything to that effect, because otherwise it is speculative. So I am going to sustain that objection and strike that particular answer from the record. You may
Yes,
proceed.
Your Honor.
May I proceed?
Yes.
Now, Ms. Baja, did your husband come back at any point?
No, he never came back. His body was never found. And that's why after 5 years, I asked to declare him dead. I needed some closure.
What do you mean by you needed closure?
Well, after 5 years of hoping and praying that Lou would come back to me, it just became more and more apparent with each passing year that he was gone for good.
What happened to your husband's estate after he was declared dead?
Based on his will, I inherited his estate, which included the Big Cat Sanctuary.
Did you receive any additional assets?
I did receive some funds from his life insurance policy.
Ms. Baja, did you forge his will?
Absolutely not.
And what happened to the animal sanctuary after your husband left?
Well, I started running the company like Lou wanted. He knew how much I loved and was dedicated to the animals in the sanctuary, so I'd never let anything happen to it, and I just continued our life's work.
Thank you, Ms. Baja. No further questions at this time, Your Honor.
Thank you, Ms. Reed. Ms. DeMiglio, cross-examination.
Yes, Your Honor. Now, Ms. Baja, on direct examination, you testified that you think your husband had a mistress. Is that correct?
Yes.
But you've never seen any text messages between your husband and that alleged mistress, have you?
No, I don't recall any.
You've never seen any emails between the two of them?
No, I don't recall seeing any emails.
You never overheard any phone calls between the two of them?
No.
You never saw her phone number in his call history?
No, I don't recall ever going through his call history or seeing any numbers in his call history.
To be clear, you've never seen any physical evidence of this alleged mistress?
No, I don't recall that I have.
Now, I'd like to talk about the last time you saw your husband alive. You last saw him on August 17th, 2012. Is that correct?
Yes, around the 17th or the 18th.
And since then, you haven't heard from him?
No, I haven't.
And no one has told you that they've heard from him since then?
No, I wish, but no, I haven't.
So, to the best of your knowledge, no one has seen or heard from Lou Donaldson since August 17th, 2012?
No.
Now, I'd like to talk about where you were on August 17th, 2012. You testified on direct examination that you were taking care of some cubs that day.
Yes, their mother had rejected them, so they needed a lot of extra attention.
And during the middle of the night, around 3 a.m., you realized you were out of milk.
Yeah.
So you had to go to the store.
That's true.
And on the way home from the store, your car broke down.
Yes, it did.
Now, Ms. Baja, you loved your husband, didn't you?
I did. He was my Prince Charming. We were soulmates.
And during the course of your marriage, you had each helped each other.
Yes, that's what you typically do in relationships.
And so you'd feel comfortable going to your husband for help if you needed it.
Yes.
So that night, when you were sitting on the side of the road with a broken down car, you called your husband, didn't you?
No, I didn't. I thought he was out of town, so I didn't call him.
Right, you didn't even attempt to see if he was available.
No, like I said, I thought he was out of town. He was always leaving the country without giving me a heads up or anything.
So that's a yes to my question. You didn't even attempt to see if he was available?
Yes.
And instead, you called your brother.
Yes, he was on duty, so I knew he would be available to pick me up.
And your brother is Officer Carl Bannister.
Yes, he's a police officer.
And your brother took you home.
Yes.
And the first thing you did when you got home was wake up your husband and let him know what had happened to the car, right?
No, it was pretty late.
Right, you didn't even check to see if your husband was at home in bed asleep, did you?
No, I was preoccupied taking care of the cubs.
You just assumed he wasn't there.
Yes, like I said before, he was always leaving the country. That was typical Lou.
So that's yes to my question. You assumed he wasn't at home.
Yes.
Now, finally, I'd like to talk about the meat grinder at Wild Wildlife. The cat sanctuary does have a meat grinder, is that correct?
Yes, there's one on the property.
And you have that meat grinder because the cats eat a lot of meat.
Yes, that's what it's for.
They're big cats.
Yep, we're the wild wildlife big cats and tigers.
So you have to use that meat grinder fairly frequently.
Well, I don't know if I'm the one particularly using it. The cubs I take care of, I bottle feed them, but it is used for the animals on the property.
And it's used fairly frequently.
I don't recall how frequently it's used.
But those big cats eat a lot of meat, don't they?
They like to eat.
They eat a lot of meat.
I would assume so.
Now, you're familiar with that meat grinder, aren't you?
I'm familiar that there's one on the property, yes.
And you know that it takes at least 2 people to operate it.
Yes.
And in your opinion, that meat grinder is large enough to dispose of a body, isn't it?
Well, I don't know if that's my opinion, but the size of it, I guess if someone wanted to assume that, then yes.
Is that a yes to my question? The meat grinder at Wild Wildlife is large enough to dispose of a human body?
It's large enough, yes.
Thank you, Ms. Baja. Your Honor, I have no further questions at this time.
Thank you, Mr. Maglio. Ms. Reed, any redirect for Ms. Baja?
May I have a moment, Your Honor?
Certainly.
May I proceed, Your Honor?
Absolutely.
Ms. Baja, are you aware if the police ever checked that meat grinder at Wild Wildlife?
Yes, they did.
How are you aware of that?
I spoke to them during the investigation.
Objection, hearsay?
Response?
May I have a moment, Your Honor?
Sure.
Now, Ms. Baja, what did you plan to do with the money that you received
Your Honor,
Your Honor, I've submitted on that question on counsel's objection.
Okay. And so I think what we'll do is we'll just strike the question, how are you aware? And then we'll just move on to the next question.
Yes, Your Honor.
Go
What
ahead,
did
Ms. Reed.
the, may I proceed?
Sorry, I didn't mean to interrupt you. Go ahead, Ms. Reed.
Now, what did the police find regarding your meat grinder?
That there was no DNA
Objection,
evidence or
lack of personal knowledge.
Okay. Response to that.
Your Honor, this witness has just testified a couple of times that she has knowledge of the police investigation. Previously, she testified that on direct examination, and now we're just asking as to her knowledge of the meat grinder, which was brought up on cross-examination.
May I respond?
Yes.
In that case, I amend my objection to hearsay. Any statements about what the witness knew about what the police did or did not test is based on hearsay that she spoke to the police and heard.
God, I mean, I'd hate to keep out this evidence because I obviously would like to know what the police conclusions were. But I've got to admit, I mean, I'm not sure how this witness can testify to that. Ms. Reed, is there another witness, perhaps an expert who's relied on the police investigation that you may have coming up that could submit this testimony? Because I just don't know how Ms. Baja is able to talk about this without me over-bending the hearsay rules.
Yes, Your Honor. There will be another witness, an expert, Mr. Chris Reynard, who will speak to the same fact.
Okay. And so I think I'm going to have a little bit of a hard time. I think Ms. Baja already testified that the police did an investigation. She kind of set the framework for us that it sounds like the police didn't find anything with respect to the meat grinder. But I think to go into details it's definitely going to violate a lot of the rules of evidence unless you can think of some exceptions. And so I think I'm going to have to sustain that objection, but feel free to bring it up with the next witness.
Yes, Your Honor, I'll move on. Ms. Baja, why didn't you call your husband the night that you were stranded on the side of the road?
He was always flying out of the country without telling me, so I figured he wouldn't be there and I needed to get back home. So I called my brother, who I knew was available and going to be able to drive me home.
And what did you plan to do with the funds that you received from the life insurance policy?
Everything I received was going to go right back into continuing our life's work at the sanctuary and just maintaining the emporium.
Thank you, Ms. Baja. No further questions, Your Honor. May this witness be excused?
She may. Thank you. Any other witnesses for the defense?
Yes, Your Honor. The defense calls Chris Reynard to the stand.
Great. Mr. Reynard, thank you very much for being here. You've previously been sworn in. Ms. Noor Mohammadi, your witness.
Good evening.
Good evening.
Please introduce yourself and tell us what you do for a living.
So my name is Chris Renard. I'm a claims investigator and forensic document examiner with Summit Life Insurance Company.
And what does a forensic document examiner do?
Well, we essentially look at various documents, various pieces of financial paperwork, and try to determine whether or not they're genuine or if there's any fraudulent activity going on there.
And how long have you been a forensic document examiner for?
23 years in total now.
Do you have a specialty?
So I do. I specialize specifically in handwriting analysis and comparisons, as well as just general, document examination.
And what's your educational background?
I received a bachelor's of criminology. That was my sort of undergraduate degree. And then after that, I attended the Statesville Police Academy.
Does being a forensic document examiner require any certifications?
It does. In fact, I am certified with the Board of Forensic Document Examiners, and I'm also certified with the Association of Certified Fraud Specialists. And both of those require sort of continuing education, routine seminars, things like that.
And do you have any other prior experience in the field of forensic document examination?
Yes. So just before coming to Summit Life Insurance Company, I actually worked with the Statesville Bureau of Investigation in their forensic document examination lab. And I was there for about 3 years.
And what are your duties as a claims investigator for Summit Life Insurance Company?
Well, whenever a claim is filed, I'm responsible for looking into it, gathering critical evidence, conducting witness interviews, looking at police reports or police investigations or accident reports as they might be relevant, things like that, as well as pulling various documents that might be at issue.
And how long have you worked for Summit Life Insurance Company?
The last 20 years.
And have you ever been qualified to testify as an expert in forensic document examination before?
I have. I've testified 25 times before.
Your Honor, at this time, I'd like to tender Chris Reynard as an expert in claims investigations, signature and handwriting identification, and forensic document examination.
Ms. Morris, any voir dire or objection to the scope of the tender or the tender itself?
None at this time, Your Honor.
Okay, great. Ms. Noor Mohammadi, your witness.
Mr. Reynard, now that we've spoken a little bit about your background, I'd like to ask you about how you got involved into this case. How did you get involved into this case?
Yeah, certainly. So I was assigned to look into this case when Ms. Baja filed her claim for Mr. Donaldson's life insurance policy. I was specifically brought on and asked to look into two specific areas that might have been at issue.
Were you asked, what were those two specific issues you were asked to look into?
Well, we wanted to look into whether or not this was a claim that our insurance company was required to pay out on. And there were some rumblings that perhaps the last will and testament was fraudulent, as well as that Ms. Baja may have been involved in the death of her husband. So I looked into both of those areas.
And how did you conduct your investigation?
Well, I reached out to a contact of mine at the sheriff's office. I pulled the life insurance policy as well as the last will and testament that were at issue. I reviewed those documents as well as other documents which had Mr. Donaldson's handwriting on them to conduct a signature analysis. And I also spoke to a couple of witnesses who had signed as witnessing the last will and testament.
Let's take those one at a time. What did you learn from the sheriff's department?
Well, objection, Your Honor, hearsay. Calls for hearsay.
Response.
Your Honor, experts are permitted to rely on hearsay in order to form their opinions regarding the investigations that they conduct.
I do agree. I think the basis of an expert opinion pursuant to 703 may be hearsay that is otherwise inadmissible. And so if that is the only objection, I'm going to overrule it and let the expert testify.
Your Honor, may I be heard?
Sure.
Well, 703 requires that such facts be disclosed if their value is substantially probative and outweighs their prejudicial effect. This contact with the sheriff's office is anonymous. It's off the record. We'll likely hear that it's impermissible as this is an ongoing investigation. So the probative value does not outweigh its prejudicial value.
Okay. Response to that?
Yes, Your Honor. May I constructively approach?
Sure.
May I provide an offer of proof?
Yes.
We anticipate that Chris Reynard will testify about Ms. Baja's alibi and the fact that the police investigated the meat grinder as well as the fact that there were some glasses found in Mr. Donaldson's abandoned van. And these are the probative value of this substantially outweighs its prejudicial impact because this goes to rebut the plaintiff's case.
Yeah, I think that it's a great argument on both ends, but I am going to have to give defense a little bit of leeway to explore this since it sounds like it's the defense's theory that he magically, not magically, I'm not trying to undermine what happened here at all, so I take that back, but that he did not simply disappear, rather something more nefarious may have happened here. And I think that that's where defense is getting at with this line of questioning. And so I'm going to give them a little bit of leeway. Great objection though, Ms. Morris, but overruled.
What did you learn from the sheriff's department?
Well, essentially what I concluded from the sheriff's department was that there was very little to no evidence regarding Ms. Baja. She was never named a suspect or arrested in any way. There was no DNA found at Wildlife Sanctuary there. Essentially, the only piece of evidence that was there was Mr. Donaldson's van had been recovered with his glasses inside of it.
And did the police investigate a meat grinder?
It's my understanding that they did.
And what was the conclusion of that investigation regarding the meat grinder?
Well, again, my conclusion was that there was no DNA or anything like that belonging to Mr. Donaldson from that meat grinder.
Now, why was the discovery of the glasses significant in your investigation?
Well, it's my understanding that Mr. Donaldson had left his glasses in his van, and his van was found at an airfield. I thought that sort of raised some questions about potentially if he was involved in an airplane accident. That's why I thought it was significant.
Now, directing your attention to Mr. Donaldson's signature on the will, you mentioned you analyzed his will. How did you conduct your analysis?
Well, the question was the signature on the will genuine? So I looked at that signature and compared it to two other signatures that we know belonged to Mr. Donaldson. Those would be his driver's license record, which had his signature on it, as well as I pulled the original paperwork Mr. Donaldson had filled out with our life insurance company back in 2005.
Your Honor, I have a copy of Mr. Raynard's signature comparison, which has been already moved into evidence as plaintiff's exhibit number 3. May I publish this?
Absolutely.
Mr. Raynard, after analyzing these 3 signatures, what was your conclusion regarding, or what did you determine regarding the authenticity of Mr. Donaldson's signature on the last will and testament?
Well, looking at these signatures, between the two that we knew belonged to Mr. Donaldson and the one that was in question, there were sufficient similarities in several areas that I felt, there simply wasn't enough here to conclude that this was fraudulent. And it is my opinion that this signature appears to be genuine. There are some differences, certainly, but they are minor.
And can a person's signature change?
Absolutely. In fact, no two signatures are exactly the same. And there are a lot of factors that play into how a person's signature might change.
What are those factors?
Well, age is certainly one. Just as we age and grow, our signatures tend to change. The speed with which the person was signing at the time, if they were in a rush, even things like the pen that was used or the surface that was writing on, these can all sort of play a role and create these differences that we see.
Thank you, Ms. Reed. Mr. Raynard, you mentioned that you were assigned to determine whether Summit Life should contest payment. What are the grounds a company could contest payment?
Well, I mean, at the end of the day, an insurance company is a business, and this was a rather large $5 million policy. So if we, at any point, if I at any point felt that there was fraud here in this life insurance policy, that would certainly be grounds to contest. Additionally, if the beneficiary, Ms. Baja, was responsible for the death of our insured, that also would be grounds to contest and decline payment.
And did you find any grounds to contest payment?
No. After my investigation, I actually recommended to my bosses and the company at large that we pay out on the $5 million claim.
No further questions at this time, Your Honor.
Thank you. And before we proceed with cross, I just want to clarify the record. I misspoke. What I meant to say is that this goes to the defense's theory to rebut that anything nefarious is happening here, not that something nefarious is happening here. So I apologize for that. But I think both sides understood where I was going. I just may have skipped a couple of words since it's getting a little bit late my time. I apologize. But trust me, I'm with you. I just wanted to clarify the record. So Ms. Morris, your witness cross-examination.
Mr. Renard, you just talked about the signature that you analyzed on Lou Donaldson's will.
That's right.
And in fact, you wrote in your report that you couldn't determine whether that will signature was genuine or non-genuine, could you?
That is true. I can't say with 100% certainty that there wasn't a forgery here, but I couldn't conclude for 100%.
And this was a report that you prepared for the CEO of your company, correct?
That's right.
About Lou Donaldson's life insurance policy.
That's correct.
His $5 million life insurance policy.
Yes, it was a very big policy, and I took my time.
And you took your time, but on this report to your CEO for a policy worth $5 million, you were not able to confirm that the signature on the contested will was genuine or non-genuine?
I could not be 100% that it was genuine or non-genuine. That is correct.
I'd like to now move on to the meat grinder that you discussed. You wrote in your report that you gleaned that the sheriff's office tested Ms. Baj's meat grinder. Is that right?
Yes, that was my understanding.
But you don't actually know whether they tested this meat grinder.
No, that's correct. I have not been a part of that police investigation.
And in your report, you mentioned no details of any test results from the meat grinder.
That's true.
And you shared no name of anyone who conducted this test in the sheriff's department.
I did not.
In fact, Mr. Renard, you shared no name of any contact in the sheriff's department. Is that right?
That's true. I did not disclose the name of my contact in the sheriff's department in that report.
So, Mr. Renard, because you don't know whether they tested the meat grinder, you don't know whether there's any bodily evidence or not.
That's true. I can't say for 100% certainty that there's something hiding that I don't know about.
I'd like to just confirm with a few dates that you discussed in your report. Lou Donaldson was last seen on August 17th, 2012, correct?
That sounds right, yes.
And Ms. Baja reported him dead, legally dead, on August 18th, 2017.
Yes, 5 years after. That's right.
5 years to the day, correct?
Yes, that was. Excuse me, sorry.
And it's the same day that she filed for his life insurance policy.
That's true.
And just to confirm, Mr. Renard, this was the first day legally possible that Ms. Baja could collect on Lou Donaldson's life insurance?
That's my understanding. After 5 years, that was when the window opened.
Thank you. No further questions.
Thank you, Ms. Morris. Ms. Noor Mohammadi, any redirect for this witness?
Yes, Your Honor. Mr. Reynard, in your opinion, was it unusual for an individual to receive payout on their insurance claim the same day that they're legally declared dead?
I'm not sure I'd use the word unusual. It certainly is not an everyday thing, but it is certainly not unheard of.
No further questions at this time, Your Honor. May this witness be dismissed?
You may. Thank you.
Your Honor.
Any other? Yes, go ahead. Sorry.
I was going to say I had no further witnesses to call, and with that, the defense rests their case.
Okay, well, thank you very much. I'm assuming there is no rebuttal case allowed for plaintiff under the local rules. And so I think that we are prepping to go into closings. Why don't I give both sides just a couple of minutes to collect your thoughts. Mr. Meglio, are you going to do the closings?
Yes, Your Honor.
Okay, excellent. So let's just start at 11:10, which is just a couple of minutes away. It's not exactly a break. Does anyone actually need like a 5-minute break, or are we good to just proceed?
Your Honor, I don't need a break, but if I may, can I request a time check?
Yes, we're calculating these times right now.
That's a good idea. Why don't we get a time check? And then, I mean, I was in your shoes a few years ago, and so I would like maybe just a couple of minutes to let you collect your thoughts before closings, not like a formal break. So maybe after we get the time check, we can do just legitimate 120-second break to let you guys collect your thoughts and go from there. But let's wait on that time check first. And all we're looking for is how much the teams have left for their closings.
Of course, we're just comparing some notes right now, Your Honor.
Sure, no big deal.
All right, the plaintiffs have 18 minutes remaining, so they've used 52 minutes of their 70 minutes. And defense has 33 minutes remaining for closing, having used 37 of their 70 minutes.
Great. Well, there's a great saying in the trial lawyer world: those who bore the jury loses. And so I'm not implying anything, but I hope that neither of you will use anywhere close to that time. But I guess it is comforting to know that you both have enough time to be comfortable. And so why don't we take a couple of minutes from here? It's 11:11 my time. Let's just do 11:13. And so collect your thoughts. We'll just start exactly at 13 after the hour with plaintiff's closings. So take a moment. Okay, is defense counsel ready for closings as well?
Yes, Your Honor.
Okay, as we established earlier, I think for closings, it is best that everyone has their video off except for the advocate actually doing the closings. And so, Mr. Miglio, it is your well. We're both going to turn our videos off and you may proceed whenever you are ready.
May I request a 2-minute warning?
I think that's going to be up to the timekeepers. I don't know what a 2-minute warning is. I think you had a lot of time left, so I'm not sure if you need it, but whoever is the timekeeper, if she is actually approaching 2 minutes, can you guys let her know?
Of course, we can give you that 2-minute time warning. Would you like us to just kind of say 2 minutes?
I think
Yes,
so. I
please.
think that's the cleanest way to do it.
Okay. For the defense, would you like any sort of time warning? I know it's hopefully not very necessary.
No, I think I'll be okay.
Perfect.
Excellent. Okay, thank you all. Ms. D'Amelio, you are well.
And may I also reserve my remaining time for rebuttal?
Absolutely.
We're here today because of three things: motive, murder, and mourning. Karen Baja and Lou Donaldson's marriage was tumultuous. Lou Donaldson told Karen Baja that he wanted a divorce. This, combined with her desire to control her husband's massive fortune and collect on his life insurance policy, became the defendant's motive to kill her husband. On August 17, 2012, Karen Baja murdered Lou Donaldson. With the help of her brother, Officer Carl Bannister, she disposed of his body in a meat grinder and presumably fed the remains to her tigers. That was the last day that Cam Donaldson saw his beloved and devoted father. And since then, he has been in a state of mourning. He'll never get another piece of advice or hear another dad joke again. When someone steals something from you, they must be held accountable. Karen Baja stole everything from Cam Donaldson. Members of the jury, only you can hold Karen Baja accountable today. Now, in order for you to hold Karen Baja legally accountable, there are some things that you must find that we, the plaintiff, have proven by a preponderance of the evidence. All this means is that you must find that we've proven that certain facts are more likely true than not. It's important to keep in mind that you don't have to be 100% sure you know what happened to Lou Donaldson. You don't even have to be 60% sure you know what happened. Under the law, a feather on the scales that tips the balance in our favor even slightly is enough for you to find Karen Baja liable. Now, at the conclusion of the trial, in just a few minutes, the judge is going to give you 4 elements. And it's up to you to decide whether those elements are more likely true than false. If you find that all 4 facts are more likely than not true, then you must return a verdict in favor of Cam Donaldson. Those 4 elements are: first, that Lou Donaldson is dead; second, that Lou Donaldson's death was caused by Karen Baja's intentional or reckless conduct; third, that Cam Donaldson suffered injuries, damages, or losses because of Lou Donaldson's death; and fourth, that Karen Baja's conduct was the cause of Cam Donaldson's injuries or damages. Now, I'd like to walk through those elements and break them down together. Let's start with the first 2, that Lou Donaldson is dead and that his death was caused by Karen Baja's intentional or reckless conduct. To prove these elements, let's discuss why Karen Baja had a motive to kill her husband. In fact, as you heard today, Karen Baja had more than one motive. Her first motive to kill Lou Donaldson was her relationship with him. Members of the jury, you heard how Lou Donaldson told Karen Baja that he was ready for a divorce. The defendant couldn't handle that. Cam Donaldson sat on the stand today and told you that as soon as the word divorce left his father's lips, Karen Baja said, "I will kill you." Lou Donaldson feared for his life. Cam Donaldson told you that as soon as his father heard the defendant's threat, how scared he looked, how he instructed Cam that if anything ever happened to him, that Cam should have the police look into Karen because she would be the one responsible for his death. Lou Donaldson was scared of the defendant, and he sought a restraining order to protect himself from her. But as you heard, unfortunately, the court failed to grant that restraining order. And rather than wait for her husband to proceed with the divorce, Karen Baja killed him. Which brings me to the defendant's second motive for murder: greed. Cam Donaldson told you how he was next in line to inherit the family business, the cat sanctuary. But Karen Baja didn't want Cam Donaldson to have the business. She wanted it for herself. Karen Baja sat on the stand today and told you that she loved those cats. They were her whole world. And members of the jury, we aren't denying that. We agree. Karen Baja did love those cats. She loved them so much that she would do anything to keep them for herself. You heard how just 2 days after Lou Donaldson first went missing, the defendant cut the lock on the office so that she could access her husband's last will and testament. But remember, no one thought Lou Donaldson was missing at that point. Why would the defendant need to access her husband's last will and testament if she thought he was alive and on a business trip somewhere? That's because she knew something that nobody else did. You also heard from Taylor Pride, an expert in investigating forgeries. Taylor Pride showed you how she compared the evidence of previous known handwriting samples from Lou Donaldson to his signature on the will. You saw those comparisons for yourself, and you saw how those signatures, well, they were vastly different. You also saw how Lou Donaldson's supposed will contained the phrase, "if I should die or disappear." Witness after witness told you how they had never seen that phrase in a real will before. This will only contained it because it was forged by the defendant after she faked Lou Donaldson's disappearance. The defense's own expert, insurance agent Chris Renard, told you how he believed the will could have been forged. Members of the jury, it is more likely than not that Karen Baja forged Lou Donaldson's will so that she would inherit all of his assets, including the cat sanctuary. These motives led the defendant to murder Lou Donaldson. Now, it's undisputed that no one has seen Lou Donaldson alive since August 17th, 2012. No one has heard from him since that day. You saw for yourself Lou Donaldson's bank records, and you saw how he hasn't spent a cent since then. You also heard how the probate court of Statesville declared Lou Donaldson legally dead 5 years after his disappearance in 2017. But the court didn't declare Lou Donaldson dead on its own. Lou Donaldson was declared dead because the defendant herself requested it at the first possible moment the law allowed her to do so. Now, the defense tried to tell you a story about how they think Lou Donaldson has been alive and living in Costa Rica this entire time. But I'd like you to ask yourself, is that realistic? Cam Donaldson told you how his father left behind his only pair of glasses and that he was blind as a bat without them. Is it realistic that he supposedly flew over 2,200 miles without being able to see at all? Is it realistic that he would leave behind $100,000 in his bank account while he was off living in luxury on an island? The insurance company, who would rather find some indication that Lou Donaldson is alive so that they could avoid paying on that $5 million policy, even concluded that Lou Donaldson is dead. So let's talk about the night that Karen Baja actually murdered Lou Donaldson. She told you today that between August 17th and 18th, she was taking care of some tiger cubs. She told you that in the middle of the night, she realized she was out of milk and had to go to the store. But recall, you saw Lou Donaldson's bank records. You saw how his very last purchase on that same day was for $940 worth of animal supplies. Do you really think that less than 24 hours after her husband had spent almost $1,000, Karen Baja was already out of milk? Did you see a receipt for the milk Karen Baja supposedly bought that night? You didn't, because you couldn't. The defendant wasn't at the store that night. This was her cover story, so that she could meet up with her brother, Officer Carl Bannister. Now, you might be thinking to yourself, why would the defendant want to meet up with her brother? But Karen Baja already answered that question for you. Karen Baja told you today that she could use the meat grinder and that it was large enough to dispose of a human body as long as she had a second person on hand to help her. That second person was her brother, Officer Bannister. The defendant was close with her brother, and she knew he was a police officer. You saw how the records for Officer Bannister's patrol vehicle show that it wasn't moving between 3:20 a.m. and 6:30 a.m. that morning. It wasn't moving because he was with the defendant, helping her dispose of Lou Donaldson's body. Now, the defense tried to tell you that Officer Bannister was just being a good brother, just dropping his sister off at home. But I'd like you to think about that. Wouldn't you expect someone who needed help, someone whose car was broken down on the side of the road in the middle of the night, to call their husband? Wouldn't you expect them to at least reach out to see if their husband was available? At the very least, wouldn't you expect someone to wake up their husband as soon as they got home to let them know what happened to the car and that it was sitting on the side of the road? Karen Baja didn't do these things because she couldn't. Lou Donaldson was already dead, and she needed someone's help to get rid of his body. The defense also tried to tell you that the meat grinder hadn't been used to dispose of a body. But I'd like you to think about that as well. If the defendant's brother was involved in the crime, and he was a police officer, would his friends on the police force really be interested in investigating? Did you see any police reports indicating the testing that the police supposedly did? Did you hear from a police officer about how they tested the meat grinder? You didn't. There is no evidence whatsoever that the meat grinder was actually tested. All you have is the defendant's word and the defense expert's assumption. Members of the jury, it is more likely than not that Lou Donaldson was dead and that his death was caused by Karen Baja's intentional conduct. Since his father was brutally murdered by Karen Baja, Cam Donaldson has been in a state of mourning. Which brings me to the last two elements. That Cam Donaldson suffered injuries, damages, or losses because of his father's death, and that Cam Donaldson's injuries or damages were caused by Karen Baja's conduct. Now, these elements are undeniable. Cam Donaldson told you today how much he loved his father, how much he still misses him. Cam Donaldson told you how he was next in line to inherit the family business. But because Karen Baja forged the will and took that business from him, he will never get that opportunity. Clearly, Cam Donaldson suffered losses because of his father's death, and because Karen Baja intentionally killed Lou Donaldson, her actions were the cause of Cam Donaldson's lawsuit. Now, after you decide whether the defendant is liable for killing Lou Donaldson, you also have to decide whether to award damages to Cam Donaldson to compensate him for what he lost. Now, we all know that no one can put a price on what it means to lose a parent. But there are a few concrete numbers that we can point to illustrate what Karen Baja took from Cam Donaldson. First, Cam Donaldson should be awarded the proceeds from his father's life insurance policy in the amount of $5 million. Karen Baja wrongfully received this money and should not be allowed to profit off of killing her husband. Cam Donaldson is also owed the deed and ownership to Wild Wildlife in the amount of $5 million. Cam Donaldson told you how he was next in line to take over the family business, but because Karen Baja murdered his father and forged the will, Cam Donaldson didn't only lose the business, but he lost the opportunity to run that business as a family with his dad. This brings me to non-economic damages. Now, under Statesville law, you have the power to award Cam Donaldson damages to compensate him for the grief, pain and suffering, and emotional stress that he suffered when his father was killed. As you think about how much that might be worth, consider, how much would a son pay to spend one more day with his father?
You have 2 minutes remaining.
Multiply that by a month, a year, 30 years. Members of the jury, we know that that number is infinitely large. But today, we're requesting $25 million to soften the blow that Karen Baja dealt to Cam Donaldson by brutally killing his father. Karen Baja was motivated by her greed and marital problems to murder Lou Donaldson. This left Cam Donaldson in a state of mourning and incalculable suffering. Today, we've proven all 4 elements of wrongful death. When someone takes something from you, they must be held accountable. Hold Karen Baja accountable today. Find her liable in the amount of $35 million. Thank you.
Okay, thank you very much. We are ready to proceed with the defense's closing whenever you're ready.
Your Honor, can you hear me? Just want to make sure you can hear me from here. Okay.
Yes, I can hear you.
Members of the jury, there is one thing plaintiff's counsel and I agree on, that the death of Lou Donaldson was devastating for everyone who was close to him. For Cam Donaldson, who lost his father, and for Miss Baja, who lost her husband and partner in Big Cat Rescue. But grief is not a valid reason to bring a lawsuit. And yet that's exactly what Cam Donaldson did. When Miss Baja lost her husband, she devoted herself to preserving and caring for her big cats. When Cam Donaldson lost his father, he looked for someone to blame to avoid the stark reality that his father chose to leave him. That's why he's here today accusing Miss Baja of murder. But in this courtroom, in this country, you can't just make accusations, you have to prove them. And here, even though Cam Donaldson can point his finger, he cannot prove the case. Now, the plaintiff has to prove their case to you by what the law calls the preponderance of the evidence. Now, to understand what that means, imagine a scale. On one side, place all of the evidence the plaintiff provided to you, and on the other side, place the defense's evidence.
If, after carefully weighing the evidence, the scale tips in our favor, even by the weight of a feather, or that it's perfectly even, then you must find Karen Baja not liable. Ms. Reed, may you please display the jury instructions? The plaintiff is required to meet their evidentiary burden on 4 separate elements. First, that Lou Donaldson is dead. Second, Karen Baja intentionally or recklessly caused Lou Donaldson's death. Third, the plaintiff suffered injuries. And fourth, the defendant's conduct resulted in the plaintiff's injuries. Now, the plaintiff can't just prove these as possible. They have to prove these as probable. Thank you, Ms. Reed. If the plaintiffs fail to meet their evidentiary burden on even one of these elements, then you must return a verdict in favor of Karen Baja. Today, the plaintiffs have failed to meet their burden for 2 reasons. First, Lou Donaldson chose to leave his wife and son on August 17, 2012. And second, Lou Donaldson chose to leave his estate to Karen Baja. So let's talk about that first point. Lou Donaldson chose to leave his wife and son on August 17, 2012. You heard how close Cam Donaldson was to his father. And when his father chose to leave him, that threatened to shatter everything Cam Donaldson knew and believed. But instead of accepting the truth, he's here accusing his stepmom of murder. But members of the jury, Cam Donaldson isn't a police officer or lawyer or judge. This isn't a criminal trial. Ms. Baja hasn't even been charged or convicted of any criminal offense relating to Lou Donaldson. But despite that, Cam Donaldson refuses to accept that Karen Baja was uninvolved in his father's disappearance. She's here accusing him of murder, but hasn't brought you a shred of evidence to support that. The one thing plaintiff has proved to you today is that August 17th, 2012 was the last day anyone in the United States saw Lou Donaldson. And that's because after that day, Lou Donaldson chose to leave. Mr. Donaldson had the means and motivation to leave his life in the United States behind and move to Costa Rica. You heard today how he owned multiple planes, but that no one really knew how many. And that months before his disappearance, he flew with a suspended pilot's license and didn't log flight plans with any of the local airports. Mr. Donaldson had the ability to pick up and leave, and the methods he chose meant that nobody would be able to trace whether or not he made it to his destination. Now, you also heard today that Mr. Donaldson has a history of leaving everything for a woman he was in love with. He did it first when he met Karen Baja. When he met Karen Baja, he chose to leave his wife and son behind. And as you heard today, he found a new love in Costa Rica and once again has chosen to leave everything to pursue that new relationship. Now, the plaintiffs have tried to paint Miss Baja of a gold digger, but that's not true. Miss Baja thought Lou Donaldson was her soulmate. She was devoted to him, and their love was rooted in their shared passion of big cats. Mr. Donaldson's decision to leave was devastating for everyone. For Cam Donaldson, who lost his father, and for Miss Baja, who thought Lou Donaldson was her soulmate. And she thought he felt the same. Now, plaintiffs have spent 3 hours trying to point the finger to Miss Baja, but hasn't brought you a shred of evidence to support their wild accusations of murder. In fact, Miss Baja didn't even see her husband the day he left. On the night of August 17th and in the morning of August 18th, she was busy devoting her time to 2 baby cubs that had been rejected by their mother. You heard today how she cared for those cubs into the night and that she had to go to the store to get them more milk. And when her car broke down, she had to ask her brother for help. Now, a question you might be asking yourself is, why didn't Miss Baja call her husband when her car broke down? Well,
Miss Baja knew her husband like she knew the back of her hand, which meant she was well aware of his tendency to hop on one of his planes and leave town. Now, we all have one of those friends who we call and we text, and we don't get a response back for a few hours, sometimes even for a few days. And when you're in an emergency situation stranded on the side of the road, those people aren't going to be the ones you call. You're going to call someone who you know is going to pick up your phone and be available to pick you up. Now, plaintiffs have tried to turn this into a murder mystery thriller, but instead of bringing you a smoking gun or even a blood-stained knife, all they've brought to you today is a transponder that may or may not be working. You heard today, Deputy Bannister works for the Sheriff's Department, and the Sheriff's Department didn't find his behavior or the malfunctioning transponder suspicious, and it's their job to prove what is and isn't suspicious. Now, you also heard in plaintiff's opening today that the evidence would show that the malfunctioning transponder was working just fine, but they have failed to bring you any evidence of that. Now, the plaintiff stood here and told you, and I wrote it down, Karen Baja disposed Lou Donaldson's body in a meat grinder and fed him to the tigers. Members of the jury, this is both ridiculous and untrue. But you don't have to take my word for it. You can rely on the investigation conducted by the police department. The police department investigated the meat grinder and didn't find a shred of human DNA. Now, you also heard some statements from Cam Donaldson. Specifically, you heard him testify that his father was a part of him, that he spoke to him every day, and that his father was the best. Yet, after his father was identified missing, he didn't try to call him, he didn't try to text him, didn't try to find any recent reports of plane crashes, didn't try to see if one of his planes was missing. If Cam Donaldson is as close to his father as he claimed, why didn't he call his father? Why didn't he try to text his father? Why didn't he try to find his father every single day? Now, plaintiff also wants you to believe that because there's one unused bank account, Lou Donaldson is dead. Plaintiff wants you to believe that a man with millions of dollars, multiple planes, and a history of leaving one life behind for another only uses one bank account. Does that sound realistic to you? So why are we here today? Two reasons: grief and greed. You heard the pain Cam Donaldson suffered from losing his father. He couldn't accept the possibility that his father would just leave him. But instead of accepting the truth, he's channeled that denial into a murder mystery thriller where he doesn't have to accept a single ounce of blame or accept the truth that he was abandoned. He thinks he's entitled to the entire company, but he cannot accept that his father cut him out. Which brings me to my second point. Lou Donaldson chose to leave his estate to Karen Baja. Now, Karen Baja wasn't the only one tricked into believing her relationship with Lou meant something more. Cam Donaldson thought his father viewed him as a business partner. But the point is, Cam Donaldson spent 20 years as an assistant, 20 years writing checks and scheduling meetings, not taking care of the animals or running a business like a true partner. He thinks he's entitled to the entire company, but that's a job he's entirely unqualified for. The only person who had the experience to fully run that company was Karen Baja, and that's exactly why Lou Donaldson left it to her. Now today, plaintiff is contesting Miss Baja's, the will Miss Baja presented to probate court and Miss Baja's receipt of the $5 million life insurance policy. Together, that's a total of $10 million. 10 million reasons to bring this lawsuit. So let's talk about the will first. Plaintiff wants you to find the will invalid because there's some differences between Mr. Donaldson's signature on the will and the handwriting samples. Now, today you heard from two experts, Chris Reynard, a forensic document examiner and claims investigator from Summit Life Insurance Company, and Taylor Pride, the plaintiff's own expert, that no two signatures are ever the same, and that signatures can vary based on the writing utensil used, where the author signed, or if the author was rushed. Now, no one here is disputing there's some differences between the signatures, but no one here can tell you what kind of pen Mr. Donaldson used, where he signed, or if he was wearing his glasses. These minor differences are not enough to contest the authenticity of the will. Now, plaintiff also wants you to find the will invalid because there's some unusual language. That language they're talking about is die or disappear. Now, no one here is contesting that language is unusual, but Mr. Donaldson didn't live a normal life. He was a multimillionaire with multiple planes and a history of leaving one life behind to start another. The evidence suggests that he wanted to disappear. He knew there wasn't going to be a body because he wasn't planning on dying. He was planning on disappearing, and that's exactly what he did. So while that language might be unusual for someone like you or someone like me, for Mr. Donaldson, it was deliberate. Now, plaintiff also wants you to find Karen Baja's receipt of the $5 million life insurance policy invalid, but we also heard from two experts today, Chris Reynard and Taylor Pride. Taylor Pride was hired by Cam Donaldson and paid by Cam Donaldson. Chris Reynard works for Summit Life Insurance Company. It was his job to find a way out of paying Ms. Baja. Now, if you have any experience with insurance companies, you know how difficult it can be to get a payout on a claim. Chris Reynard investigated the circumstances around Lou Donaldson's disappearance and the last will and testament and didn't find any indication whatsoever that payment to Ms. Baja was unwarranted or improper. Plaintiff couldn't accept that his father cut him out. Now, in the plaintiff's search for the perfect scapegoat, he hit gold. By pegging Ms. Baja with his father's murder, he would become his father's heir, making him the sole beneficiary of a $5 million company and a $5 million life insurance policy. Now, you also heard today about a prior will and how that will gave Mr. Donaldson 25% of his father's estates. But today, he's done only getting 25% of what he thinks he deserves. Today, he wants it all. But he hasn't brought you a shred of evidence to suggest he's entitled to anything. Ms. Reed, may you display verdict form B? After I'm done speaking, opposing counsel will have another opportunity to speak. And after that, you'll receive two verdict forms, but you only need to sign one. This is the verdict form that deserves your signature. Thank you, Ms. Reed. Now, as you learned throughout today's trial, it was easier for Cam Donaldson to believe that someone took his father than to accept his father chose to leave. It was easier for Cam Donaldson to believe that he was entitled to the entire estate than to accept he was never more than an assistant. It was easier for Cam Donaldson to believe that the will was forged than to accept his father cut him out. But you aren't called today as jurors to do what's easy. You're called to do what's right. Today, we ask for the just verdict, the right verdict, a verdict finding Karen Baja not liable.
Okay, thank you. Is there a rebuttal?
Yes, Your Honor.
And just for the time check, you do have 50 seconds for that.
Sounds like a very brief rebuttal.
Yes. Now, the defense tried to tell you that Cam Donaldson is pointing fingers, but the only one pointing fingers here today is Karen Baja. She's asking you to believe that a grieving son is nothing but greedy to hide the truth. She killed her husband, motivated by her greed, and caused Cam Donaldson to be in a state of mourning. Find Karen Baja liable in the amount of $35 million. Thank you.
Okay, well, that concludes today's proceedings. I hate to do this on Zoom, but if everyone could at least unmute yourselves so we can give everyone a round of applause, because this is not easy to do over Zoom. You guys are rock stars. I mean, I honestly have to applaud you at least for trying to do this. I think if I was in your position, I would have been like, you know, I'm opting out this year. I don't know, maybe next year. But you guys are rolling with the punches like no tomorrow. Kudos to you. So I just want to make sure I've got my attendees list up. I still have both of my scoring jurors, which is great. Thank you, everyone, for sticking around. I know it's pretty late in at least the East Coast. I don't know where everybody is from. Don't tell me yet. But I'm assuming just kind of all over the country. But either way, it's pretty late. So I won't keep you. Hopefully the scoring jurors won't keep you. But I do want at least the scoring jurors to kind of introduce themselves, tell us what they do for a living, or if they are a lawyer or non-lawyer, because I think you all know the Summit Cup prides itself on the idea that we bring at least a non-lawyer into each round, because when you all become jury trial lawyers, you're not going to be doing your trials to lawyers. Otherwise, you will have done a terrible job at voir dire. So, Ms. Santos, if I may start with you, if you want to just kind of introduce yourself to our advocates, just tell us a little bit about what you do, who you are, and then we'll go from there.
Yeah, definitely. Hi, my name is Gabby Santos. I am currently a master's in public health and public administration student in Denver, Colorado.
Thank you very much for being with us. I know that this must have, been a huge time commitment for you to do. So we really, really appreciate you being here. I think that we all have to invest in the future generation of lawyers, right? So thank you very much for doing that. And Ms. Farut, if you can introduce yourself as well, tell us what you do, anything that you'd like to say.
Hi, good evening. So I am an attorney. I'm a deputy district attorney here in Colorado. I graduated in December, so I'm not so far removed from law school. I thought you guys all did really fantastic. I was a member of the trial team while I was at DU, and so I know what all of you must have been through as far as preparation, and to do it on Zoom, like Coach Sada said, I really commend all of you. I can imagine the extra preparation and planning that went into that. And I thought your guys' presentation was overall fantastic. So thanks for that.
That's great. What district are you?
Adams County.
Oh, great. Okay, wonderful. Very nice. Well, I introduced myself earlier. My name is Deanna Sada. I was a coach on the trial team at DU for a little while. I'm a former prosecutor. I was a prosecutor in the 18th Judicial District, which is Arapahoe County. I am now a partner with Berg Simpson, which is a private law firm. It is based out of Colorado, but I am the person who is expanding the firm into Florida, hence why I am in Florida, and I am the Florida office. We have 4 offices here, but I'm by myself. And so I just kind of go in each office and pretend like each one of them is occupied so that I don't shoot myself in the head, because it's quite lonely sometimes when you're by yourself. I'm kidding a little bit, but it's great. I mean, we have 2 offices here, but like 4 office spaces. What I mean is, don't take where you guys are for granted, because it is a wonderful time to look ahead in your career and want to do anything and everything. I think you should all absolutely do trial law, because that's what you're cut out to be. Please don't do transactional work. Don't sit behind a desk. I don't think any of you will be okay with that, because all of you are way too good at what you're doing right now. I think our scoring jurors will agree with me on that. I challenge you to continue getting better. I think that if you speak with any of my former trial team students, they will tell you I'm one of the few that never kind of let them get complacent or sugarcoat anything. I will tell you when I think you need to work on things. And so I'm not going to sugarcoat it for you guys either. You guys are very good, but there's a lot of room for improvement. I'm not saying that to be critical. I'm saying that to encourage you to keep pushing, because you're never going to be perfect. None of us are perfect. I'm not perfect. I'm not near it. No one is. But you can still get so much better in your evidence and your rule numbers and your objections and your responses. And I encourage you to continue working on that, because it's like an addiction. Once you start knowing every exception to every rule and the case law that corresponds with that, you just feel unstoppable. And that's when you can take your advocacy to the next level, because knowledge is power. And so when you have knowledge about each and every single rule of evidence, with your guys' advocacy skills, you're going to be unstoppable. You already are. Obviously, you're in the Summit Cup, you're competing and you're doing well, and all of you are phenomenal. But I can see that all of you have a much higher ceiling, and I am not going to be the judge who's going to tell you you're already there. I'm going to be the judge who's going to tell you I challenge you to reach that ceiling that I can see in each of you. So go for it. Congratulations. You're done. It's almost midnight my time, 10 o'clock your time at least. So go get some rest. And I hope that you guys all kill it in this tournament.
Thank you so much.
Thank you.
Have a great night, guys.
Great job, you guys.